PIL Sumoto 1/2020.
Lord, can I take your lordship's leave just for 2 minutes, my lord? On a point, my lord, my learned friend Mr. Kohli, while addressing your lordships, tried to persuade that the insertion of 371A is an infringement on the constitutional provision, my lord.
Pardon me?
It is an infringement on federal structure.
Mr. Kohli did not say so.
Yes, yes, my lord. That was one of his arguments.
No, no.
My lord,
He does not make any submission against the what do you call
federal structure.
federal structure. No,
My lord, in my written note, I have made.
no, no.
Anyway, my lord, if
No,
it is,
it was Mr. Balgopal who had said that if that is the interpretation being given, then it is an infringement.
yes.
That if that is how the Union of India is trying to take over the oil without giving any compensation, monetary compensation to the state of Nagaland, and this is how it would become an infringement of the federalism in the constitution. Mr. Balgopal, am I right? You're muted, Mr. Balgopal. You're muted.
Oh, I'm sorry. I've been muted.
Can you hear us?
Can you hear my note now?
Yes.
I'm sorry. I'm muted.
Did I remember it correctly? Your submissions.
That's right, man. I don't know from where he got that. Maybe when he wrote it, he might have got mixed up a little bit. Your lordship is right.
well, if he hasn't said so, it's okay. But in my written note,
No,
Mr.
in
Kohli-
fact, I don't remember. Mr. Kohli, do you remember that?
So I made no such submission. No, in fact, what I had said is, no, the distribution of powers in list 1, 2, and 3 is, no, the federal structure which has to be followed and it has to be kept intact. That was my submission, Manoj.
Yes. That's
Anyway,
what.
but in any case, if I'm not on that. If it hasn't said, it's okay. There is the end of the matter. Now, your lordship will kindly see page 191 of 2024 SCC Online 2880. It is not necessary since he did not make submission on that. But then I would like to take your lordship to that paragraphs which had made the thing very clear.
Which one?
My lord, para 191, my lord. I have flagged it, my lord.
If my learned friend could just share the citation also with us, Manoj.
Yes. That is 2024 SCC Online 2880.
This is the MMRDA judgment.
On 6A.
This is on Article 6A of the
Yes, exactly.
of the Citizenship Act.
My lord. Now this speaks like this, my lord. To that extent, my lord, I wanted to make clear. Asymmetric federalism have been there in the country. Lord, just for can I take your leave, man?
May I proceed, lordships?
Yes, Mr. Jamil.
On the last occasion, the proceeding was interrupted in view of some subsequent and urgent developments that has taken place. I was making some clarification on the submissions made by the council for the respondent number 8. And in judgment,
you were on 2003 7 SCC 546.
That was with regard to the maintainability of the petition that is already over. I have
Yes,
I have cited the paragraph 51, Roman 10 and 11.
50.
Yes.
उधर से उनको ले आने बोलो उधर से उनको ले आने बोलो
उधर से लाना है
Uh,
तुम पहले नाश्ता करो जाना जहाँ भी जाना है बात बताओ नाश्ता करो
please mute someone. It's coming from where? Some unauthorized. Is there somebody unauthorized in the line? So there been any unauthorized person? No. Okay.
May I proceed, Lord?
Yes.
Next citation, Lordships. My learned friend has referred to 2004 4 ACC 489, that is Gujarat case, to show that regulation and development of all fields, natural case belongs to union in terms of Gujarat case. That was the argument advance. And that's point.
Which case was you are referring to?
2004 4 ACC 489, that is Gujarat case, a case from Gujarat Lordships.
2004 4 SEC.
489.
Okay, Gujarat Steels.
Yes, Lordships. On the regulation and development of oil fields, natural case belongs to union in terms of that case. That is what was submitted. I have one line reply on this, Lordship, and clarification. This judgment is irrelevant so far as the state of Nagaland is concerned. The judgment is relevant without Article 371A. So generally speaking, in general terms, whatever my learned friend has submitted is perfectly correct without 371A. But when it comes to interpretation of 371A, then the citation is irrelevant. Why it is irrelevant? Because of the fact that Article 371A is a special provision with a non-abstandi clause. That is why the judgment is not relevant. Why it is irrelevant? Because in that judgment, there is no reference about Article 371A. It was a case about other states. So in that view of the matter, the judgment is irrelevant. Therefore, the entire submission on the point that regulation and development of all fields and natural case belongs to the union in terms of that Gujarat case is irrelevant and misconceived, Lordships, because that is not a correct interpretation. The second judgment, another judgment, 2008 14 ACC 408. This is Bimalangshu Roy's case, a case from Assam with regard to the appointment of parliamentary secretaries.
2008.
2018.
18.
14 ACC 408. My learned friend, Mr. Shishir Toto, has referred to few paragraphs, that is paragraph 23 to 30. I will refer only two paragraphs to show what is the scheme of the Constitution. Only to show that only, Lordships. I will refer to only two paragraphs. That is paragraph 29 and 30 only. Bimalangshu's case. to show the scheme of the constitution, what is the source of power, to show that. Has your lordship got it? Paragraph 29 and 30. I would like to read, lordships.
Yes.
May I read, lordship? Paragraph 29. It must be remembered that this court repeatedly held that the interest in the various lists of the 7th schedule are not source of legislative power, but are only indicative of fields which the appropriate legislature is competent to legislate. 30. The task of this court in identifying the scope of an entry in the list contained in the 7th schedule is not easy. While examining the scope of the entries, this court must necessarily keep in mind the scheme of the Constitution. I will focus on this, the scheme of the Constitution relevant in the context of the entry in question. Now, what is the scheme of the Constitution? What is the source of power to make law? The scheme of the Constitution, if we look at the dictionary of scheme, then dictionary as per the Oxford Dictionary meaning, a systematic plan for achieving a particular aim. So the scheme of the Constitution should be aimed so as to achieve a particular target. So what is an aim? The aim of inserting Article 371A in the Constitution with a non-obstante clause as a special provision is to grant some benefit, grant some power to the people of Nagaland to make their own law in the 4 clauses as is mentioned in Article 371A. I think that will be the aim of the Constitution, scheme of the Constitution. Otherwise, what is the meaning of inserting the article in the Constitution just in order to deprive or deny? Therefore, to know the scheme, what is the scheme? What is the aim? What is the object? We have to understand the statement of objects and reasons of the 13th Amendment of the Constitution. That is therefore, Article 371A is the source of power. It is the source of lawmaking power for the state, giving in view of the scheme of the Constitution, lordships. Therefore, we can safely say that all road leads to Article 371A, and not that all roads leads to the Union Parliament to make law, lordships. The source of power under 4 clauses is Article 371A, and the scheme of the Constitution of Article 371A is very, very clear. Now, on the last occasion, on the insistence of this Honorable Court, my learned friend, Mr. Kohli, has submitted his gist up submission. There, he has mentioned 10 points. Out of 10 points, Lordship has taken out about 3 points to make submission on that. But by reading the gist of submission, the line of argument, it appears that my learned friend is not very clear on his concept and vision. What is required to be decided in this PIL? And considering the points which he has mentioned in the gist, it is found that as if Article 371 is not a part of the Constitution. Therefore, Lordships, it needs clarification. Otherwise, we may take to the wrong direction. We need to clear our vision. If the mirror is not clear, by clearing it, we can see clearly. But if there is a cataract in our eyes, even if the mirror is clean, we cannot see clearly. I have been saying, Lordships, K. Surana, wrapping your eyes frequently. Maybe there is some problem in the vision. That is why it needs rectification and clear. So we have to be very clear in our vision. So similarly, to decide this issue, we have to be very, very clear on our vision and aim, where we should land. Otherwise, if we go on listening to all the irrelevant submissions and issues, then we'll miss our way. And that may lead to wrong direction, and that will lead to committing mistakes, Lordships. If I'm wrong also, I may be corrected, and whatever I'm making submission, everything will be found in the records also. Therefore, I'm very, very careful what I'm making submission, Lordships. Now, out of the 10 questions, 10 point, Lordships, it is like 10 commandments in the Bible, which is very popular. So the points which he has submitted is also 10 points. The first point, Lordships, A, how confidence is granted, whether to the union or the state government under the scheme of constitution. So scheme of the constitution, I have already submitted while referring to Bimalangshu's case. So I need not repeat on that point, Lordships. But if I remember correctly, my learned friend has not made much focus, emphasized in submission on the background how Article 371A has been inserted in the Constitution. He has argued and submitted with regard to the implication of laws made by the union, states in the general terms, but no specific submissions. Why 371A has been inserted has not been argued. I'm grateful to the Learned Advocate General that he has made the submission and the background, how 371A. So I need
At the cost of interruption with your kind permission, I think my Lord has permitted them to argue only 2 or 3 points. The others were not allowed. I leave it to your Lordships.
Exactly what Learned Advocate General is saying is correct, because that was the instructions given by this direction given by this Honorable Court.
Let us restrict ourselves to that.
But I had mentioned in the introduction that unless we are very clear on what we are doing, there is chances of going astray. That's why I'm trying to go one by one. I will not take much time. Only to make it very clear, I'm trying to go one by one on the points which he has submitted. So, no argument has been advanced. How Article 371A has been inserted in the Constitution, the background, which is very, very vital and important, but he has not built in this area. That is why it has become necessary to reply one by one also, to make clarification. B, 1B. Is Article 371A an enabling article which grants confidence to legislate, or is it a disabling protective provision which empowers the Legislative Assembly to protect the rights specified in the article? So on this point, I would like to submit in this way. Why it is protective? It is protecting certain rights of the
But Mr. Jamir,
lordships.
I think Advocate General was right, because once you make that submission, then Mr. Kohli by default gets an opportunity to make a rebuttal.
That
He-
is
Yes.
absolutely correct. I fully agree with that.
Yeah.
He has been submitting
It's your choice.
on several occasions. So I will not take much time, just short claims. And then there are a few points where
It's not a question of time. Once you touch it, then by default, Mr. Kohli gets it.
It will be unfair to the state. Please restrict yourself kindly to only those portions which the Honorable Court has suggested. It will be very good on your part.
In fact, Lord, may I just clarify again at the cost of interruption, Lord, for which my learned friend will also forgive me. Lord, in fact, on the insertion of Article 371A, detailed submissions were made, Lord, on the 9-point agreement, the 16-point agreement, the history of the entire article, and how it came about to be inserted. After that, Lord, we had also, I had, Lord, taken the liberty of taking my Lord through the Podial's judgment of the Honorable Supreme Court, which dealt with, Lord, 371F, which was the Sikkim article, and over there also, it starts with the word notwithstanding, and we had deliberated, I had presented my case on how the interpretation of the word notwithstanding has been understood by the Supreme Court and declared by the Supreme Court. All those arguments were made. I would just make one request. I'm grateful to my learned friend for having pointed out that all the arguments were misdirected. If he could just point out, which part and how they were misdirected, that I'll be grateful for that. The declaration that they were misdirected is for the court to decide, but which part and how they were misdirected, if my learned friend is able to precisely point that out, I may be able to address, his
yes,
apprehension.
I can do that. I
Yes.
can do that with the permission of the Honorable Court, Lord.
That's why we had an old fable of Pandora's box. Once you open it, you can't put it.
Kindly restrict yourself, Mr. Jamir,
Yes.
to the points which have been put forth by the court. Kindly do that.
All
We
right.
need not go outside. That's in our interest. In the interest of the state, everybody, in the interest of justice. Kindly restrict yourself.
Then let me come back to that which this Honorable Court wants to hear on the points.
Yeah, that's right.
That is 1G. In 349 of List 2 does not in any manner grant any confidence to the state legislature to enact any laws with respect to regulations and development of oil fields and mineral oil resources. This is in the form of a reply. I believe nobody argued on this in 349 List 2. So this is a new introduction, new point, which has been introduced in the form of a reply. Whether it will be necessary and whether it will be permissible. Because in 349 List 2 is about the decks on land and building.
Absolutely.
It is a fresh submission which he is making. But so far as this point is concerned, Lordship, the 9-judge judgment in paragraph 171 and 172 has already answered. The copy which Lordships are having is that printed one, that is paragraph 171 and 172. Otherwise, the issue of decks will come after a decision is taken. Who has the power? Whether it is the Union Parliament or the state legislature has the power to make law under 4 clauses on Article 371A. Once that is decided, who has the power to tax, who can make the law and tax, all these things will come.
Nine judge bench, you mean that mineral development case?
Yes, yes. In short, I refer it as Mada case.
You are referring to paragraph?
171 and 172. Since this was already referred to, I am not reading it out.
Yes.
And then I believe my learned friend will also not make submission on the other points, since on the direction of your lordships, I'm arguing only on these points. Otherwise, if my learned friend comes on the other points, some clarification will be required. But most of the points which he has shown is, I fully agree that 9 point, 16 point all gone, it is only 371A. Exactly. In that context, I follow the role of a traffic police. That vehicle is going and in the same direction, they are let it go. I fully agree with him. 9 point and 16 point all gone. Only the 371 is left. We are trying to interpret that. And 9 point and 16 point are the background. Why this 371A has been inserted in the Constitution. Let's see.
Yes.
Next is point number 3. How the royalty revenue from the development and regulation of oil fields will be distributed between the landowners, state government, and the union government is dependent on the agreement akin to the production sharing contract. Is a matter of negotiation between the parties. It is as good as the earlier point. At this stage, it will not be relevant because once it is decided who has the power to make law, then it will automatically come. So it will not be relevant at this stage. That is what I feel. And the last point, that is on point 4, the transfer, ownership and transfer is very different from regulation and development, merely because the union seeks to regulate the development does not in any manner mean directly or indirectly that the union seeks to own or transfer the petroleum products. So that is the point number 4. We have to read the entire article as a whole. A conjoint reading is necessary. We are concerned with clause 4, that is on ownership and transfer. Ownership and transfer of land and its resources. It cannot be read half. a conjoint rating is necessary. Transfer of land and its resources. It has no two parts in the article, in the Constitution, in Article 371A. Transfer of land and its resources. It has to be written in that manner. You cannot sit in two boats at a time. A banana cannot decide to become an orange.
What?
It remains what it is by nature. It remains, it is as it is by nature. So something has been done with certain objectives and you want to make it change to another. That is not possible. Even if you try also, it will not be possible. And in the same way, bringing two donkeys together to make run like a horse, it cannot run like a horse. Donkey will remain as a donkey. It cannot run as fast as a horse. It is like that.
But in
Let us not distort in our vision.
if you care to move around the country, there is one state where it is called a minister.
Kola?
That particular word you used in one of the state in the country, they are called ministers.
Yes. And so far as this point is concerned, Lordship, I would like to refer to a judgment, the ninth judgment, the Mata case.
Yes.
That is already answered because 171 and 172, I have just referred to two paragraphs. I think I need not waste time on that. Lordships are having that judgment. Now, I will just come to the conclusion because these are the only 3 points where I have been allowed to address. So I'm making clarification on these 3 points only. But to conclude my reply, Lordship, and the clarification, we have to keep in mind about all the judgments rendered by this Honorable High Court, by the division bench in the Rosemary's case, more particularly the paragraph 29 of the judgment, which the Learned Advocate General has referred to already, and the judgment which has been passed in by the ninth judge. In short, the Mata case, which we are frequently referring to, this judgment has clarified everything about the land. In the paragraph which I have referred to, everything is very clear. In clear terms, it has been explained. So no more clear explanation will be required more than that.
You are referring to which paragraph?
171 and 172 of the what is the power of the owner of the land? Land includes, everything is mentioned there. Both minerals and resources are the product of the land. And Article 371A, Roman 4, transfer of land and its resources. Second. And Lordships, Sikkim's case, that R.C. Botial's case. I have been asked not to make submission on this, so I have not replied, but few paragraphs I have referred to. That is paragraph paragraph 14, 124, 126, and 176. That is 1994 supplementary 1 SCC 324. Mustn't. I would like to again refer to one judgment. How special law is to be treated, how the non-obstandi clause to be interpreted, which law will have the overriding effect. On that point, a constitution bench which was decided in 1963, it is reported in AIR 1964, Supreme Court 207.
Please give this addition again.
AIR 1964, Supreme Court 207. If we go by SCC online, 1963, SCC online, Supreme Court 19.
What is the point you are trying to make?
How a special law is to be treated. One, how a non-obstandi clause is to be interpreted. Which law will have overriding effect? We are confronted with all these issues and points. So I would like to refer to two paragraphs.
Yes.
As your lordship's got it.
Yes.
I will just straight away go to the relevant paragraph. There is paragraph 18 and 19. May I read?
Just a moment. Paragraph?
Paragraph 18 and 19.
Yes.
May I read, Lord?
Yes.
I will read only two paragraphs. With this background, let us now consider the following two questions raised before us. One, whether Article 372 of the Constitution is subject to Article 277 thereof, and two, whether Article 372 is subject to Article 278 thereof. Article 372 is a general provision, and Article 277 is a special provision. It is settled law that a special provision should be given effect to the extent of its scope, leaving the general provisions to control cases where the special provision does not apply. I will stop there so far as this paragraph is concerned, and kindly come to paragraph 19. 19. That apart, even if Article 372 continues the pre-constitution laws of taxation, that provision is expressly made subject to the other provisions of the Constitution. The expression subject to conveys the idea of a provision yielding place to another provision or other provisions to which it is made subject. Further, Article 278 opens out with a non-obstandi clause. The phrase notwithstanding anything in the Constitution is equivalent to saying that in spite of the other articles of the Constitution, or that the other articles shall not be an impediment to the operation of Article 278. While Article 372 is subject to Article 278, Article 278 operates in its own sphere in spite of Article 372 too. The result is that Article 278 overrides Article 372, that is to say, notwithstanding the fact that every constitution taxation law continues in force under Article 372, the union and the state government can enter into an agreement in terms of Article 278 in respect of what B states, depriving the state's law of its efficacy. In one view, Article 277 excludes the operation of Article 372, and in the other view, an agreement in terms of Article 278 overrides Article 372. In either view, the result is the same, namely that at any rate, during the period covered by the agreement, the states cease to have the power to impose the tax in respect of the work contracts. So there was an agreement. That is why, since it is covered by the agreement, then union law will prevail when, to the extent where the agreement has covered. Otherwise, the special law will prevail. That is what it means. And then, so that is with regard to the 3 points. How a special law is to be interpreted, how a non-obstandi clause is to be interpreted, and which article will have overriding effect over the other. And coming to our case, Article 245 and 246 are subject to Article 371A. Not that 371 is subject to 245 and 246 because of the non-obstandi clause. Let us anticipate and presume a situation. Had there been no non-obstandi clause, then there is no point of discussing all this. Therefore, the non-obstandi clause is to be interpreted why it has been inserted in this. That is the reason why I was making submission on the earlier occasions that when this Article 371A has been inserted in 1962 by the Parliament, all these articles of 245, 246 were there in the Constitution. 7th schedule was also there. But in spite of that, this article has to be inserted. So to make it more clear, I would like to refer to another judgment, which my learned friend is Toto wanted to refer, but I will refer to only 3 paragraphs, which are very, very short, and all the points are very, very vital and very, very important. Every words are very important in these 3 paragraphs, Lordships, which concerns our case. It's 2024 SCC Online Supreme Court 2880. This is decided on October 17, 2024.
Name of the parties?
Name of the party is Henry Section 6A of the Citizenship Act 1955. This is
Okay.
pertaining to Citizenship Act.
Yes.
Relevant paragraphs, I will refer to only 3 paragraphs, which are very, very short. 191. 192, 193. Has your lordships got it? Or may I just read it slowly if it is not available with your lordships?
Yes.
May I read paragraph 190? 191, sorry.
191.
Indeed, India's federal structure allows for diverse relationship.
191, somebody had already read. Mr. Datta has read, I think, 191.
191.
We have marked it.
Okay. He has not read out what the lordship has read, I think. Then 192 and 193.
Yes.
Few lines only, lordships.
Yes, yes. You can read, make your point. You can read.
May I read from 191 because the connectivity will not be there if I skip 191.
Okay.
Indeed, India's federal structure allows for diverse relationship between the union and its constituent states, enabling the parliament to engage in different agreements based on distinct regional aspirations, political needs, and state-specific requirements. The Assam Accord, along with introduction of Section 6A, is not the only instance of such political compromises. Historical records, documents, numerous occurrences such as Article 371A of the Constitution, which we are concerned, which was inserted pursuant to the agreement between the Government of India and the leaders of the Naga People's Convention. Similarly, Article 371G was incorporated pursuant to a memorandum of settlement between the Government of India and the Government of Mizoram and the Mizo National Front. Identical is the basis of Article 332, Clause 6, that is with regard to the tribal areas in Assam, which was based on the agreement between the Government of India and Assam and the Putu Liberation Tigers. These agreements and provisions are based on asymmetric federalism, recognizing that different states may have unique circumstances and requiring differential treatment. 192. Moreover, this conclusion is also supported by various decisions of this court, which have held that based on the unique historical circumstances of each state, the states may be grouped under different classes for the purpose of reasonable classification under Article 14, 193. We thus do not find any fault with the government, nor do we dictate the similar agreements should have been met with other states when Parliament entered into a political agreement with Assam alone, based on its unique historical situation. Lordships are well aware of this judgment. Parliament was conscious about the insertion of the article itself. What to keep, what not to keep. Now, I would like to refer to the Constitution Article 371G, that is in respect of Mizoram. So far as Assam is concerned, lordships are well aware about only the scheduled tribe will be eligible for election in the autonomous districts of Assam. So I'm not making any elaboration on that. But on Article 371G, special provision with respect to the state of Mizoram. Here, I would like to refer to Clause 1, Subclause A, Roman 4. A similar provision with the state of Nagaland with respect to Article 371A, almost in the same line, But one word and which is very, very vital and which we are discussing is missing and is not inserted, not a part of this article. That is Roman 4, ownership and transfer of land. Lordships are well aware. In Article 371A, it is transfer of land and its resources. Ownership and transfer of land and its resources. Regional classification to make law, taking into consideration of the historical background, political background, and the agreements which has been entered with the government of India. All these factors have been taken into consideration, and now I believe the law is now crystallized. It has become very, very clear. The cataract in the eye has already been removed. So now the vision is very, very clear. Constitutional provisions are very clear. Therefore, I believe we need not take much time on these issues. The law, the Constitution bench, 9-judge bench, all the judgments has clarified how it has to be interpreted. Therefore, Lordship, to conclude my submission, besides the judgments, I am concluding that to interpret this 371A, few things are very, very vital. That is, one, the historical background. In one of the notes points, my learned friend Kohli has mentioned that 9-point agreement has gone, 16-point agreement has gone. It is only 371 which is left. I fully agree and concern with him. In this context, I would like to refer one Assamese saying. I do not know whether it will be correct. In reference to Lao, the guard. My learned friend Kohli will not be aware what is Lao. It is guard. Lao do horo hole oporot thake, ar dangor hole tolot thake. The guard, when the flowers are there, you can see from distance also, because the color is white. Any passerby can easily see, oh yes, something is there. It is there. But that is already gone. Now, only the guard is remaining, and unless you look down from the bottom, you cannot see from the top. Therefore, in order to ascertain the real meaning, what is there inside, you have to look down and then look at the background. Without that, without any flowers, there can be no fruit. And why there is fruit? Because of the flowers. And flower is no longer there. It's gone. I fully agree. 9-point gone, 16-point also gone. Yes, it now 371A remains. But because of 9-point and 16-point, 371A is there in the Constitution. Therefore, the statement of objects and reasons of the 13th Amendment of the Constitution, the historical background, the political background situation, the uniqueness of the history should not be overlooked, and that should be taken into consideration while interpreting 371A. Otherwise, there is chances of derailing our attention to another direction, which our posterity may not accept also, I feel. So the historical background, political aspects, statement of objects and reasons of the 13th Amendment of the Constitution, parliamentary debates, all these are very, very vital so as to arrive to a conclusion on this issue. With regard to the maintainability and registration of the Somuto PIL, I have already highlighted to your lordships why it was registered, how it was registered, And then what the law says, those argument has already been made, Lordship, submission has already been made. So with that, Lordships, I would like to conclude my submission unless it is so necessary. I will not take the time also. Lordships have been saying that all sweet things must come to an end. But I would like to conclude that whatever has happened has an end.
Arguments are never sweet. It is good, but it cannot be sweet.
That all good things must come to an end. That is what Lordships has said. So whatever has happened has an end. With that, I would like to conclude. Highly obliged, Lordships.
Yes, Mr. Kohli.
No, I believe, no, I'll take it, no, that I have half an hour to complete my submissions, no, no more than that. Two or three things, no, before I start. Uh, I have just notes those 3 points which my lords had indicated in the 10-pointer that I had submitted. But no, just before I start, I'd like to just point out one or two things, notes. No, I don't know why and how this impression seems to have crept in, my lords, that uh, Nagaland is not a part of India has been a part of my submission. I don't know how and why, Mlod, this has crept in. This was never even remotely suggested by the union. It is not so. In fact, Mlod, the union stand has always been it is an integral part of India. It is India. And therefore, Mlod, it's only when we express, pursue, or Mlod, actually insist on our uniqueness and how we are different is when we are actually presenting that we are different from the rest of the union. The union doesn't believe so. Everybody is the same before the law. Whatever the constitution provides, the 9 point, 16 point, everything culminated into Article 371A. My submission is going to be that the rules of interpretation of the constitution are extremely well settled over the last 80 years now. We do not go into external or earlier, whatever are the points of discussion for the interpretation of the Constitution. The words are plain and simple. I've troubled my lords with all the judgments of the Supreme Court, 7-bench judgments, synthetic and chemicals also, which clearly stated that if the words of the Constitution are clear, we don't need to go back. We don't need to go into external influences or external factors which will influence the interpretation. So, Mlods, 371A as it stands in my very humble submission, Mlods, is an extremely clear article which does not broker any insistence on that we must go into the historical facts or anything related to that. All that was taken into account when 371A was incorporated in the Constitution. Now, to keep going back to the 1930s or earlier British India or the Chinese war or wherever, that is all immaterial. It doesn't help the cause at all. It doesn't further the argument any more than what it has already in terms of 371A. And now, if I could just with that bother my lords for a moment, possibly for the last time in this case, at least, to please, please have 371A for a minute. And I say this, I bring my lords to this just so that, just to demonstrate the completeness of the arguments from all sides, that this is all argued, done. There is nothing, else except a judgment now, which has to be delivered by this honorable court. My lords are with me on 371, lords?
We have read it so many times that we were just discussing.
Yes.
We have read it more than the framers of Article 3.
Yes, and the wordings are so clear. I say it only, it starts by the word special provision with respect to state of Nagaland. No dispute on that. It is a special provision. Please see, one says notwithstanding anything in this constitution. The word notwithstanding, what it means, we've gone through several times now. We've gone through Podial also. Have already, the contours of, at least from our side, we presented. Now, we only await a judgment from this honorable court on what, whether Podial, it's a constitution bench Supreme Court judgment, which defines it. Really, that has to be followed in my most humble submission. Now, after that, A says no act of parliament in respect of 1, 2, 3. Milords, we've gone through 1, 2, 3 also. By default, 1, 2, and 3 are either covered in the subjects are either covered in list 2 or in list 3. And therefore, Milords, when the Act of Parliament doesn't apply, the state legislature's competence automatically kicks in. That part also we've covered. There is no difficulty in as far as A, 1, 2, 3 are concerned. Now, as far as 4 is concerned, Milords, where it says ownership and transfer, and then it says of land and its resources. Now, Milords, dealing with the second part first, land and its resources, Milords, we've gone through the host of judgments, and even the 9-judge bench, Milords, the MRDA judgment versus sale also clearly says land and its resources, Milords, its resources would include the minerals below the land. That part is also clear. So, I can't be heard arguing against a 9-judge bench judgment of the Supreme Court. So, that part is clear that the minerals will belong to the person to whom the land belongs, whether it is a union, the state, or a private party. All three possibilities are there. Now, the most important part which this honorable court has to, in my humble submission, be interpreting is ownership and transfer. Now, would ownership and transfer include regulation and development, or regulation and development occupies a completely different field compared to ownership and transfer? The struggle today, my lords, is clearly, and now, my lords, if I could just invite my lords to the entry, which is, my lords, the relevant entry. If my lords will have list 1 of the Constitution, I know my lords have gone through this several times earlier also. My lords, I seek the favor of just one more time, my lords. List 1, my lords, in the 7th schedule, and entries 52, 3, and 4. My lords are with me?
Yes.
Yes. The Malod would recall notes 52 deals with industries, which is fundamentally covered under entry 24 of list 2. And Malod, that is why over here it says the control of which by the union is declared by parliament by law to be expedient in the public interest. So Malod, unless the declaration is there, industries doesn't come to union, Malod. And similarly in 54, where it says regulation of mines and mineral development, to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient. So, Mulod's minus, absent the declaration, the union doesn't, no competence is conferred on the union, Mulod's. Now, in contradistinction to 52 and 54, please see 53. 53 has no such antecedent or any precursor requirement. It's 53 simply says regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by parliament by law to be dangerously inflammable. The declaration from parliament is only to the limited extent of dangerously inflammable, nothing else.
Yes.
Yes. So, Manoj, 53 is a standalone entry which the parliament, which the constitution provides. The competence is solely resting with the union. Now, Manoj, the judgment my learned friend referred to, the Gujarat judgment, that is, Manoj, associated natural gas judgment. I just know yes, which is Manoj 2004, 4 Supreme Court, 489. Now, over there, while specifically interpreting 53, entry 53, the court notes in the constitution bench has categorically held that oil and mineral oil resources are all covered under 53, and only the union has the competence to legislate on this topic. Nobody else. Now, my lords, I had taken also in line with this, I had taken my lords through all the articles of the Constitution where competence was granted. My lords, right from 270, 246, my lords, where 245 and 246, my lords, which is the principal power, the distribution of the lists. 246A, my lords, which dealt with GST, which is, my lords, 249, then national interest, 250 emergency, 252 MLOs where two or more states could actually agree that the union will MLOs, 253 international agreements and 262 water disputes. And gone through each one of those MLOs. We had even gone through Schedule 6. If MLOs would recall, Schedule 6 categorically for Assam, Tripura and Meghalaya, MLOs carves out provisions where specific competence has been granted to the regional centers or the district centers or the state government to legislate on certain subjects. Now, Manoj, in the last several Manoj, occasions of hearing, no provision has been shown to my lords where the state of Nagaland would actually acquire, the legislative assembly would acquire competence with respect to mineral oils. There is no provision which has been shown to my lords. There is absolutely no provision at all. In the Constitution also there is none. Now, my lords, their only argument is that no 371A is the one which enables. Now, my lords, I've also argued that I don't need to bother my lords again with that 371A is not an enabling provision. It is a disabling protective provision. It disables the applicability of any act of the union if it relates to those four subject matters. But it does not confer any power correspondingly on the legislative assembly, my lords.
Lord Chiefs, this submission was made several times on earlier occasions.
Yes, and no answer has come forth for it. No answer has come forth for it. No provision has been shown.
Make an answer on that.
No,
If
Mr.
not
David,
constitution.
David, please don't interrupt Mr. Kohli. Yes.
No, Manoj, my learned friend had also mentioned about something about Manoj's vision and cataract and how things are not clear. But Manoj, may I submit, things will be clear if there is an alternate which is presented. No alternate has been presented at all. There is no source of power which has been presented before this honorable court that this is the provision. And Manoj, unfortunately or fortunately, Manoj, we are a country governed by law. There is a constitution which must prevail. And if in the constitution there is no such power which has been granted, then so be it. Merely because Manoj, we have Manoj, emotional feelings, or we have a thought, or we perceive how it should be, would not Manoj be a substitute for the constitution. The constitution must prevail, and the law declared by the Supreme Court and this honorable court will Manoj, guide all of us on how to discharge our obligations as citizens of this country. Now, my lords, there is no provision which has been shown to my lords on how the competence to actually legislate on 371A falls upon the state legislative assembly. And my lords, my stand is that if there is no such provision, then development and regulation, now, my lords, more so in the 9-judge bench judgment, they have categorically, my lords, made the distinction between ownership and development and regulation. Now, Manoj, once that is so, that distinction is so very clearly now laid out by 9 judges of the Honorable Supreme Court, Manoj, there is really nothing left for all of us to, Manoj, take my Lord's time on. And that distinction must be honorable. What 371A talks about is ownership and transfer. What we are concerned with is development and regulation. That's one part of my submission, Lord. On that 1 and G, in the note that I had submitted. Now, may I just point out one thing, on this, which I wanted to just take 2 minutes on, that entry 49 was not something which I'm bringing in, There was some argument made around entry 18, 48, 49, and how those gave competence to the state government or the state legislative assembly. Now, if will just be with me on the list, and if will just please see the lists, Look, there is no competence which comes forth either in, we'll start with 14 of list 2, which was one entry which was argued before, my lords. Please see entry 14. My lords are with me?
Yes.
Yes. Look, entry 14 deals with agriculture, including agricultural education and research, protection against pests, and prevention of plant diseases. It was not even remotely connected to mineral oils or their regulation and development. 18, land, that is to say rights in or over land, land tenures, including the relationship of landlord and tenant, collection of rents, transfer and alienation of agricultural land, land improvement and agricultural loans, colonization. Look, nowhere does it deal with mineral oils, development and regulation. And development and regulation of mineral oil no way impinges on transfer and ownership or tenancy or Malod's alienation or improvement. After that, Manoj, may please see the next thing was a set of Manoj 45 to 49, which is the entries relating to tax. Now, Manoj are aware, Manoj, in the constitution, it has been so interpreted that the power to levy tax or impose tax is completely different from Manoj ownership, transfer, regulation, development, everything separate. Taxes, you need a specific conferment of competence, only then are you able to actually tax. Now, my lords, therefore, my lords will find from 45, it says land revenue, assessment and collection of revenue, maintenance of land records. 46, taxes on agricultural income. 47, duties in respect of succession to agricultural land, again, duties. 48, estate duty. 49, taxes on lands and buildings. For the life of me, I can't figure out how taxes on lands and buildings is concerning mineral oils. And this was not a new argument from my side, this was an argument which was made, and I'm only saying, that these are all irrelevant. These are not sources of power. These are not subject fields which cover mineral oil in any manner at all. So it can't be that they go, that they can be sideways or a side door by which they can come in. That is not a possibility. Now, if will have finally just the last point, which my lord said, point number 3. If Manoj will have the MA MADA judgment, Manoj Mineral Area Development Authority, if Manoj will have that judgment. And if Manoj will be with me at para 263. Manoj, para 263, which starts with the decision in Theresema Jacob. My lords are with me?
Yes. 263, somebody had read it earlier.
No, I had taken that liberty.
Yes, yes.
Yes, 263, which starts by saying the decision in Theresema Jacob held that the MMDR Act does not declare the proprietary rights of the state in mineral wealth, nor does it contain a provision for divesting the owner of a mine of proprietary rights. Rights in minerals generally follow ownership of the land. the right of an owner of land extends to the subsoil, including the minerals found underneath the soil, which continues until the state deprives the owner by a valid legal process. Now, two things come out of this. One, the fact that the ownership of the minerals lies with the owner of the land is undisputed. The second thing is that the state can divest them of that right only through a process known to law, not otherwise. And then it goes on to say, importantly, Section 16(1)(b) of the MMRD Act also recognize the rights to minerals does not automatically vest in the state government. Now, there is no provision in the Oil Field Regulation and Development Act which says that the oil belongs to or the minerals belong to the union. After that, we'll see 297, which is on the continental shelf, which is on the exclusive economic zone of India. And after that, if I could just invite my lord's attention to para 268 straight away, which settles it completely, Manoj, in my humble submission. 268, my lords, have?
Yes.
The above discussion leads to two conclusions. First, the owner of a land can be divested of subsoil rights in minerals only through a valid process of law, which has generally taken the shape of land reform legislation enacted by state legislatures. Second, the MMDR Act does not vest the ownership of minerals or mineral rights in the state. It regulates the exercise of rights to minerals which may be owned either by government, private person, or by both the government and private person. Now, Manoj, why I make the point of that production sharing contract in Manoj, in my 10-point biblical submission, Manoj, as fell from my learned friend, Mr. Jamir, Manoj, is because the production sharing contract is something which the government of India also enters into with private developers. And Manoj, they develop the oil field and the government shares the profit petroleum, or the petroleum would include everything, Manoj, over there, oil, natural gas, everything. And the government then shares it with them. So that is an arrangement, Manoj, which is there. Nagaland may or may not like it, may like to follow it. That is a subject matter of negotiation, Manoj, amongst the union and the private landowner and the state of Nagaland. And that is a stage yet to come. We are right now, Manoj, purely on the question of competence. Does the state of Nagaland have the competence to issue, Manoj, the petroleum rules they have, or to pass the resolution that they have? Where the resolution, Manoj, to the extent it says that the act will not apply, fine, may, Manoj, hold up muster. If they are able to show that it deals with ownership and transfer. In my humble submission, it doesn't. It deals with regulation and development, so that resolution is completely, Manoj, untenable. And second, Manoj, the rules which have been framed are without any competence at all. Those are the two major issues in the, Manoj, PIL, and those two issues we've addressed in great detail, Manoj. Now, my humble submission, Manoj, after this is going to be, if Manoj would reserve judgment and Manoj oblige us with a judgment, Manoj.
We'll just a moment.
All the other points, Manoj, which were my learned friend, Manoj, the learned AG, read in great detail the various opinions from eminent Manoj, legal personalities of this country. But Manoj, those are mere opinions. Ultimately, it is the constitution and the declaration of the law by either this court or by the Supreme Court, Manoj, which will prevail.
In fact, in this constitutional issue which has been raised, it was a pleasure hearing all of you. That's first.
I would like to make some submissions in the end. Last time I had asked for a few minutes.
Yes, what do you have to say?
My lord had referred to only one or two points which I'll take to. Firstly, that there was reference that in the various opinions given by the various jurists, there was a reference only of entry 54. There was only there was reference only of entry 54 and not entry 53. Lordship is right. But have they obliterated 53? I'm now coming on to that very question. Because if there is no reference of 53, then this oil, petroleum, everything is. In this context, my lord, I may have to refer to a few paragraphs in one of the written submissions which I have given earlier on these opinions, copies of which I have given to my learned friends, some of whom I have referred to some paragraphs from this. First, my lord, I hope your lordship has got that, my lord. I've also made arrangements for additional copies also.
You can make your submissions, we'll follow it.
I'll submit that.
Hmm. Yes.
One is the opinion of the then Solicitor General, which later in the submissions, my learned friend has said that we don't accept it or it was not accepted. Whatever it is.
Yes.
At page 3, my lord, of this opinion, paragraph 3. My lord has got it, my lord. It's not that, my lord. Written submission. Ask Shibu to so to give it. That's the one, madam. That's the one.
Yes. Yes.
My lord has got it, madam.
Yes.
Kindly hand over a copy, please, Mr. Mitra or somebody.
We have it.
Okay, well. So, paragraph 3, my lord.
Yes.
Whether the Nagaland State Assembly is empowered to make rules or in respect of ownership and transfer of land and its resources. In response to this query, I reiterate and conclude that the State Legislative Assembly resolving to make laws or rules in respect of ownership and transfer of land and its resources, including mineral oil, to determine the terms of usage and to control matters of exploration and production of minerals within the state is valid and in line with Article 371A. I'm just starting to. Similarly, my lord, if your lordship were to see the next page, page 4 at paragraph 5, it gives the complete details of what is land. I'm not reading it out, especially Ananta Mills, which I will come to later. My lord has got that, my lord?
Yes.
Then, my lord, I skip this and come to page 7, para 8, HM Sirvai.
This you had explicitly read.
Yes. But ultimately, my lord, I'm just drawing your lordship's attention to it. The same way Nariman, Mr. Nariman, at para 10, page 10, again he speaks of land and resources. Finally, my lord, page 15, this is important, man. Page 15. Sarkar's views. The aforesaid observation are applicable to all states in India, but not to Nagaland, which has been accorded a special status under 371A1, a law of parliament regulating mines and mineral development enacted in exercise of its powers under 53 of List 1, is a law within the meaning of land and its resources referred to in Clause A of Article 371A. And I have taken the view that such law would not apply to the state of Nagaland without the consent of the Assembly. I presume that no such consent has been given. My answer to this question, therefore, is that the Legislative Assembly of Nagaland has plenary power to legislate. This is important, my lord. I think my lord is not voting.
Yes.
Has plenary power to legislate with respect to entries 18, 23, and 50 of List 2 without being subject to any control exercises by Parliament by law. So, my lord, it's not that in these opinions it refers only to 54. They refer to entry 54 and they describe entry 53 also. And they also give the plenary powers as far as land is concerned, which gives competency to the legislator to make the law, because the land includes all the resources within that. So it is not that everything should be given step to step, as I had mentioned earlier. My next point, my lord, is that I also refer to something which is undisputed. That is, which talks of 53, the opinion of the Attorney General, which was given to the then minister concerned. In that opinion also, they have categorically stated that the Parliament cannot make a law with respect to any item mentioned in item 53. That opinion has been accepted by the government, and that has been referred to and filed by the Union of India in this matter. Right. Then, my lord, to cap it right from the inception in 1960, we have referred to entry 53 and 54, which was not accepted at all. Now, one question I would like to submit for your lordship's kind consideration. The talks between Government of India and the Naga representatives started in 1946.
Mr. Bhalgopal, we have already.
Just 1 minute, man. I won't go into all the points at all. Kindly bear with me for a minute. It took 16 years to agree to 371A with the non-obstant clause. 16 years, man. Only when they introduced the non-obstant clause in 371, it is only at that stage that people have accepted it. If you were to visualize an area wherein, as being mentioned by Mr. Kohli, that you are completely helpless, you can't do anything about it. And let us presume that these regulations apply. I will come to my second point. Just bear with me only for 5 minutes, madam.
You are putting words which he did not say.
No, I am saying so, madam. I am saying so. I am just saying presume. I use the word presume. Presume. The second alternative comes into picture that these regulations apply. The parameters of these regulations are restricted to dangerous substances, public interest. Now, the final point is, if I establish that Article 371A has been breached by the central government, by in the garb of these regulations imposing complete restrictions on taking away the revenue of the state, not mentioning even the name of the state in the various agreements, specifically saying that they are owners of the oil mill, where does the state stand in this type of situation? My lord may also remember the NIO, which we have referred to earlier, in which all these questions have been done. The last provision.
98.
Finally, my lord, as
Yes.
far as asymmetrical federalism is concerned, my lord may also keep in mind the Kashmir matter. The Citizenship Act, they have already.
I'll take it.
They'll forward this judgment to you, my lord. I've just given it to my colleagues who are sitting there.
Yes, we have it.
Right. So, paragraph 178, man. I need not read it for your lordship. It is only speaking of asymmetric federalism. Just like how it is given in the Citizenship Act, the reference in Assam, and the earlier ones.
Lordship, we are supplying only just the relevant portion only with those paragraphs.
We have it, not a problem.
Therefore, my lord,
23, 1.
therefore, my final point, my lord, is that if 371A is to be interpreted, my lord, the way the Union of India is doing, then what is the advantage the state of Nagaland got in this? We got nothing.
What?
How are we different from others? We are only asking, my lord, even if you were to see the Procedural case, if your lordship were to just see Procedural case, I think it was in para where they speak of the resolution, etc. Just the last reference. I'll just draw your lordship to page 171. Last submission. Only last submission.
Repetition.
I wanted to speak on the resolution, my lord. Kindly bear. I have argued it at length. I'm grateful to your lordship. I'm just touching upon a new point, that is the resolution. In 171, they say, para 171 of the Procedural case, Sikkim was not admitted in the Union on the basis of any treaty. Fine. So ultimately, when you come to the next page, they speak of unanimous resolution was passed by the Assembly of Sikkim on 10th April. After the said resolution has been approved by a majority as the special opinion, the said resolution does not contain any terms or conditions in which the people of Sikkim want to join the Indian Union. But this establishes what is the force of a resolution. Even when Sikkim wanted to join, they went by a resolution given by the then assembly. But in that resolution, they didn't specify any terms. Whereas in our resolution, the terms are fixed. That's my submission in this. Further, in the words of Krishna, my lord, you cannot use the constitution to defeat the constitution. The interpretation given by the Union of India defeats the purpose. I'm placing the judgment also on record, my lord, Justice Krishna's judgment. using the constitution to defeat the constitution. I don't want to impinge on your lordship's time because I have argued the matter at length. I was just brushing upon these small points.
Yes.
That's all my lord, from my side.
No, just want one line answer, Manoj, for this, which I wanted.
It's
Manoj.
okay.
Just one line.
We
Manoj.
have it. We
Yes.
have it. Otherwise, this debate will never end.
No, Manoj, my learned friend specifically said that if presume for a moment, and he was kind enough to say, assume for a moment that the regulations are valid, then
allow us
Manoj,
to-
the government.
allow us
that-
some discussion now.
Yes, absolutely, Manoj. I'm only saying, Manoj, if the government, the resources, cultivation is also a resource of the land. If the government says that you will not cultivate opium because in the larger public interest, drugs are not a good idea, now, Manoj, that can't be a restriction which defeats the rights. So my only submission is that, Manoj.
This is just picking hay here and there. We are concentrating on something which gives
Yes,
revenue.
absolutely. Also, these
So you
submissions,
cannot
Manoj,
take
that
away the
restrictions
revenue
take away
in the garb
everything.
of all these things.
Yes,
It's
yes.
not acceptable to the state.
It's
Yes.
okay.
Grateful for the very patient hearing, Manoj.
City Jamil, Learned Amicus Curie.
Lord, counsel for the High Court is also present.
Yes.
Lordship, I will submit my written argument.
Yes, please.
My lord, just one
You
minute.
will give it in course of the day today?
Lordship, by tomorrow?
By tomorrow morning, okay.
I will also need some time to put in my written submissions, Manoj.
If that is the case,
You also can do it by tomorrow.
I'll also place my
Manoj,
written
tomorrow,
submission.
tomorrow would be a little difficult. Manoj, may give me 10 days time, Manoj.
10 days we'll be in vacation.
My lord, what we remember, your lordship last
We
time
will
said,
be on vacation.
during the course of the argument, it will have to be filed. So, my lord, our argument is ready. We are filing it. Now, one thing.
In fact, today the arguments have all concluded. Manoj, we'll Manoj, formulate ours and we'll submit it within 10 days time, Manoj.
That was the understanding last time. This is Shurana expressed.
By Monday or Tuesday, we'll file it. If it's okay with Kohli also.
My lord, your lordship has, my lord, seen that Mr. Kohli argued that we did not reply in regard to whether we have any entry to pass any law by the state of Nagaland. My lord, all of us have argued entry 18 is the befitting entry. And my lord, everywhere your lordship will find, in the opinion of all the jurists, your lordship will find that entry is the free entry, my lord, is not subject to the list 1. And even if it is subject to list 1, my lord, that has evolved by virtue of Article 371A. And para 260, your lordship kindly, that judgment of the 9 judges, your lordship, just for a while, your lordship kindly see. It has said the legislative power of state to enact any legislation can be traced to entry 18 of list 2, which empowers the state legislature to legislate with respect to matters dealing with land, that is to say, rights in and over land, comma, then there are others, it is compartmentalized. Now we are concerned with right in or over land. Now beneath the land, Melu, the petroleum and all these things are there. And the state has all the power in the world to make any law. Now that is, Melu, this is undisputed, since the entry 18 is a free entry. Just a minute. Melu, your lordship kindly see para 63.
You just in your note you put it up.
Yes, sir, I
Because,
already clarified that. We shall put, and then,
we are, in fact, not interested to hear more.
no, I understand, my lord. I could get. the
Once it
thing.
is over, it is over.
No. What I want to say, para 63, they wanted to give a picture is applicable to the state of Nagaland is not at
You
all.
are putting up a note, Mr. Datta, please give it in that.
Just 1 minute, my lord.
No, not even a minute, because once it is over, it is over.
No, what I want to say that in these paragraphs, the understanding is there is given for other states, not for the state of Nagaland. So in view of Article 371A, this is 263 and 268. Your Worship.
Then what we propose to do is we keep it after the vacation.
No,
We
have
keep it for hearing.
No, I have finished.
No, we'll keep it for hearing because we don't want unsatisfied senior counsels going ahead. In the meantime, you file your written argument.
My written.
My lord, may conclude it, my lord. This we have done everything. Everybody has done there. I think he has exceeded a little bit.
We are giving a date, 22nd of July.
No, my lord, I have
for further
finished it.
hearing.
I'm not arguing anymore.
Further hearing and written note of submissions.
I
Submissions
have
of
no
Mr. C.T. Jamil, learned amicus curiae, assisted by Mr. A. Ozukum, learned counsel, who are present through video conferencing, is concluded. Reply submissions is concluded. The submissions of Mr. Vivek Kohli, learned senior counsel, who has appeared through video conferencing, assisted by the same counsel who were there earlier in the last order.
Siddharth Barua, my lords.
Siddharth Barua. Okay. Mr. S. Barua and Mr. K. Kalita.
And Nitika Bajaj also, my lords.
Okay. And Nitika Bajaj. The counsel for respondent number 8 is also concluded. Submissions of Mr. K. N. Balgopal, the Advocate General of the State of Nagaland. Appears to
Along with
video conferencing along with Ms. N. Nambiar, learned counsel.
Nitya Nambiar and others, the list I have given, my lord. So,
Ms.
Mr. Bitso, kindly hand over the list of appearance.
Yes, okay.
All those who are present.
So concluded.
Mr.
Of Mr. S. Datta and senior counsel, along with Mr. A. Dasgupta and senior counsel, and assisted by Mr. S. Datta and counsel for respondent number 7 remains inconclusive. List again for the hearing on 22/7/2025. Post of the note of submissions should a written note of submissions, if any, by the parties should be emailed positively within 10 working days. 10 days from the date from today. Next this for further hearing on 22/7/2020.
My lord, what is the date? What is 23rd?
So that is free. It's a Wednesday.
22nd July.
My lord, could it be on 23rd? We are having delimitation in the Supreme Court, my lord. I'm sorry, on 22nd. If it is not inconvenient to your lordships, 23rd or before that also.
24th.
24th. I'm sorry, my lord, for making this. I was just informed.
24/7, okay.
Kindly.
So written should come by 27th. We fix a date. Written submissions by 27th of June. 27th of June. Make it,
So far, our written argument we are filing today.
okay.
Lords, 27th is a Friday. Would my lords consider, my lords, making it 30th of June, which is a Monday, my lords?
Will be closed. There will be
Oh,
vacations.
I'm so sorry, my lords.
We have delayed vacations, so 27th is the last working day here.
No, 27th it will be then, my lords.
Lordship, I beg to mention for listing of these three petitions, Your Lordship. Your Lordship, our family members have been picked up by the police authorities. Since then, we don't know about their whereabouts, Your Lordship. So tomorrow, Your Lordship.
May I please, Your Lordship? So I beg to mention for IA, my lord, for minor correction of the last order, Your Lordship.
Please, Lordship, I beg to mention a matter for urgent listing for tomorrow.
At
For
what
motion-
stage?
For motion,
Motion, okay.
obliged.
Lord, I beg to mention that for urgent listing, madam, this was the last post on 15/5/2004. There were not listed. This will
It goes after vacation, not before that.
please, border police presenting this, them.
If required, you file an IA, but otherwise matters will not be listed.
Oh.
Before vacation, is no chance of listing a matter.
Item 1 for admission, WP Criminal 18/25.
Yes, your affidavit is okay?
Yes, sir.
Okay.
File affidavit, man.
No. You filed your affidavit, but
Yes,
this
sir.
is re-registration WP criminal. It will suffice. Okay. Yes, what is to be done now?
My lord. In this case, my lord, the husband of the petitioner was arrested. My lord, kindly go through the page 37. FIR.
You have seen that he jumped into the river and he died.
Yes, my lord.
Yes.
And since the incident till date, he is unable to trace out by the police as well as by us also. And we are claiming by this petition he had already died, and state are claim that has not died. He is abscond from the custody of the police. This is the case. My lord. After vacation, my lord, may fix a date for admission hearing, my lord.
Total, my lord,
Final disposal.
14 case was pending against him. Page 99, clearly, we have all stated all things, my lord. Page 99. Brief of the facts of the case. ma'am.
In the page 44, bottom part, stated that how he jumped from the boat. That fact is stated here. In the affidavit, he stated that he is a habitual criminal, and while he was taken to the some places for investigation purpose, and definitely he was with handcuff. And a person with handcuff, how can he jump from the boat within the barricade of the police? There is also, my lord, no question.
No.
My lord.
It's, if you go to learn swimming, you will know that your hand has to be together to jump into the water. At least we see that from the Olympians when they make the diving. I have no experience like them, but their hands are always together. once people dive to water from a height.
So I'm saying for after vacation, the date may be fixed for admission carrying.
And what has happened in the trial court, whether whether he's been declared to be an absconder? In trial court, what has happened?
From the trial court till date, my lord, we have
That's
not
pending.
received any notice, my lord, for
Pending.
pending.
Mr. Sharma, please get us information about the status of the case in the trial court.
Thank you, sir.
Pending and secret. In my lord, in separate court, about 14 case pending against him. One Nongbu PS case number under section 32092, Umayam case number, Mukalmoa PS case number, Mukalmoa PS case number.
Oh, that is one part, but when he
Rakibul PS
escaped, he
case.
was in police
Total
custody.
14 case pending, separate.
But when he escaped, he was in police custody.
But in any case, he was never not convicted till date.
Nalukbari PS case number, Nalbari, Soegaon.
Antecedents are not good.
Admittedly, State Judge had stated.
This is
lots of cases.
Bayata Sarili police station case number 182 of 24. Correct?
Yes, ma'am.
Yes, my lord. 182/24.
You can just say both sides are represented. The learned counsel for the petitioner as well as Mr. P. Sharma, learned standing counsel for the learned additional senior government advocate for the state shall make an attempt to obtain instructions as to the status of the proceedings of the proceeding arising out of Bayata Sarili PS case number 182 of 2024. Just to inform the court as to whether the petitioner, namely, the husband of the petitioner, namely Monwar, Monuwar Hussein, alias Babul Ali, has been declared as an absconder or not. Next, for the learned additional senior government advocate is at liberty to send a download copy of this order to the officer in charge of Bayata police station to enable him to obtain the information. Just in absconder in Bayata Charlie police case number also, or in any other cases pending against him. You get the information if he's declared to be an absconder.
Yeah.
Next para list Give date after vacation.
Twenty-one-7.
Yes,
23. 21 I have something, 23.
23, okay.
23-7.
Much good.
Supply item 7 for admission.
In this,
Yes, you have the information.
my lord, in this meeting, my lord, I was supposed to get instruction, my lord. The Lord said they give me 2 day time, my lord, to this. I have sent it, my lord. I have not received back, my lord. Day after tomorrow, my lord.
Both sides are represented. Mr. J. Pang, Leonard's standing counsel for the FT matters, has submitted that he has that he has already communicated the order dated 13/6/2025 to the authorities, and he prays for and is granted. Time to obtain time to so as to enable him to obtain instructions. Next para list on. Thursday is 19/6/2023.
My lord, grateful.
Other matters in FT matters, we are not taking up hearing, we are taking up APSC matters.
Supplementary item numbers 8 to 55 for hearing.
I appear, my lord, in item number 47. 14 of 2022. Video. দুটা সেট করে দিয়ে না নেক্সট সেকেন্ড কোন they go and show him now one set is two. No, this is not one of it. Give me the constitution. Let's as I said, my lords, I appear, my lords, in item in street appeal number 14 of 2022, my lords, for this lady called Suranjita Hajarika, who was, my lords, appointed as the district transport officer. In the combined competitive examination of 2014, my lords. Now, my lords, the lordships recall, my lords, the order was passed in exercise of powers under 19 of the Assam Transport Service Rules. And my lords, the sheet anchor of my submission before your lordships, my lord, when I started my submissions was that in that subsequent verification process, my lords, which is nothing but an inquiry, the officer concerned has a right to be heard. Now, my lords, the state's plea, my lords, I must tell your lordships, my lords, is somewhat disappointing, my lords. The state, my lords, in my respectful submission, my lords, has taken contradictory stance, which my learned senior, my lords, D.K. Mishra said is confusing. Mr. Mishra said it is confusing, my lords, but I will take it further, my lords. It is contradictory, self-contradictory stance, self-defeating stance. And in my respectful submission, my lords, they have played, my lords, ducks and drakes before this court. The state, my lords, the overarching argument, understanding of the state, my lords, rest will fall in place. Mr. Kohli, my lords, started his arguments and he's ended his arguments with his submission that the appellant has no right. And his argument was, my lords, and that's, my lords, that, my lords, is the overarching stand of the state, my lords. Rest will fall in place, my lords. The stand of the state, my lords, is there is no infraction of right of any of the appellants. Not only, my lords, is there no infraction of right, there is no violation of fundamental right. Well, that's the stand of the statement. All other arguments, my lords, fall within this umbrella, this canvas. The state, my lords, has discharged 57 employees without giving a hearing, without any notice, by a stroke of pen. And state has the audacity to tell this court, my lords, that no right of the petitioners have been infracted. My respectful submission is today, my lords, these appellants have not even been treated with respect, even like animals, my lords. Even animals have rights today, my lords. State says they have no right. That's their stand, my lords. And in that overarching, my lords, submission falls the other submissions, which I will, my lords, counter. And it is very disappointing, my lords, for a state to take a stand that they don't respect the rights of the appellants. They say there is no right. And because there is no right, we can hire and fire you, we can throw you out. You have no, we owe no obligation to the appellants for the resultant action of discharging them from service. But that's the point, key point. Well, this takes me, my lords, to the next argument of the statement. I'm just giving what the state's stand is.
that they are probationers. So it makes it even worse. Firstly, my lords, no right, no fundamental right infracted, my lords. Second, my lords, these are a set of probationers whom we can throw out without any notice. Forget about Article 311, my lords. 311, they say, my lords, is not applicable to probationers, my lords. I will make good that submission, and your lordships, my lords. Thanks to Mr. K. Chaudhary, my lords, handing over a judgment of your lordship sitting singly, my lords. In Imran Barbhuyar case, my lords, your lordships have said, my lords, even for a probationers, relying on Purushottam Lal Dhingra, that Article 311 protection is there. Provided, my lords, the test is met, namely, my lords, does it lead, my lords, to a stigma, or is it punitive? Now, my lords, the second argument of the state was, it was, my lords, when he, in the summing up of Mr. Kohli, my lords, it was a bit good to hear, because he argued during his arguments that Article 311(2) protection is an exception, not the right. Your lordships, my Lord Justice Surana, stop and query from him. Will you elaborate on this submission? Because it is difficult to accept that the constitutional right under Article 311(2) is an exception and not the rule. In his summing up, my lord, my learned friend, my lord, made a course correction, and he says that Article 311(2) is not disputed. It is applicable, but in this case, since they are probationers, they have no right to the post. And, my lord, he further, my lord, qualified it that these are simpliciter discharge orders, which is not punitive. That's his understanding, my lord. And the police investigation says report amounts to the objective material for the subjective satisfaction of the government, my lord. We are playing, my lord, with words here. Objective material for the subjective satisfaction of the government. And there is no intent to punish these probationers. And suitability was applied, my lords, to these probationers when the state found that they were not suitable to continue. My lords, objective material for subjective satisfaction, these are all jargons, my lords. Ultimately, my lords, these officers who are before your lordships have been discharged from service without a notice, without any opportunity of hearing. And the submission made by my learned friend, my lords, that this is discharge order simpliciter. It is based on suitability of the probationer. My lords, flies on the face of the discharge order of my client. The lordships recall my discharge order, my lords, at page 249. It's a detailed order, my lords, referring to the Dibrugarh police station case, referring, my lords, to the corruption allegation against the client, referring to some section 27 disclosure, my lords, relating to discovery, referring to the sanction order, and eventually, my lords, exercising powers under 19.1 and 19.2. Your lordships recall them. During the arguments, my lords, this discharge order was not touched. The state has not answered, my lords. My case, my lords, if your lordships recall, my lords, that I don't have to, my lords, go beyond the order. I am not even asking for your lordships to lift the veil, because this order itself is stigmatic on the bare reading of it. It is punitive. And the direct and proximate cause, my lords, of my client's discharge is the investigation in Dibrugarh police station case. That's the direct. So, my lords, Mr. Mishra also, my lords, painstakingly, it's a, my lords, a live link. On principles of natural justice, my lords, I had, my lords, in my opening argued that principles of natural justice will have to be read into Rule 19.2. That subsequent verification process is nothing but an inquiry. And the finding which is arrived at, my lords, the words are, it is found on a subsequent verification. So my argument, my lords, was for your lordship's kind consideration, my lords, was that though Rule 19.2 does not explicitly provide for a hearing, my argument was, my lords, hearing will have to be read into Rule 19.2. And I had argued, my lords, that the justice of the common law will supply the omission of the legislature, since there is an omission here. And that, my lords, is a uniform law. I relied upon, my lords, that RBI circular case, if your lordship recall, by fraud circular of Rajesh Agarwal, Justice Chandrachud's argument, the judgment, where, my lords, the court read in, my lords, the principles of natural justice into the provision. Otherwise, my lords, Rule 19.2 will confer arbitrary, unbridled, and unchannelized powers, my lords, to the state. Now, my lords, the third argument, so, my lords, on principles of natural justice, my lords, now, my lords, a different argument is, my lords, placed before your lordships. My lords, on principles of natural justice, there stand, my lords, if your lordships recall, in the affidavit in opposition, my lords, at page 257 of my appeal, was, if your lordship just had 257 minutes. minutes. It is submitted, my lords. Your lordships will. I had placed it, my lords, during my opening. Yes, page 257, your lady.
We have marked it.
Yes, it is submitted that Rule 19 of the 2003 rules does not mandate compliance with the principles of natural justice before exercising the power of judge. So, my lords, the decision maker is stating, my lords, before this court, that we did not give you a hearing because Rule 19 does not mandate. Now, my lords, this argument is further elucidated, my lord, in the additional affidavit at page 284. My lords, para 58. It is settled law that any probationer is liable to be discharged from service anytime without issuing notice or assigning any specific reasons. So, my lords, the decision maker tells the court, discloses to the court that we did not grant them a hearing because Rule 19 does not mandate a hearing. And being probationers, they are not entitled for any hearing. There was a without prejudice argument, your lordships recalls, where, my lords, they argued that we have dispensed with the inquiry. That your lordships will find at 286. But these are all contradictory stands. 286 says, my lord, please see, my lord, when the lordships asked me, my lord, that without prejudice means they don't want to bind themselves. My answer to your lordships was that this cannot be a without prejudice argument. And they have further explained it, why they have dispensed with the inquiries. Lordships has them without prejudice to the foot of the page. It is most respectfully submitted that in terms of the proviso to Article 311, whenever it is observed, it is not reasonably practicable to hold any such inquiry, and this says under 311(2), it will not be necessary to give such person an opportunity. I had, my lords, placed Tulsiram Patel, paragraph 133. Taken your lordships to the discharge order at 249. It makes no mention of dispensing with the inquiry. Tulsiram Patel says the discharge order must disclose if you have dispensed with the inquiry. Right, my lord? Now,
Tulsiram Patel was paragraph
133, my lords. Tulsiram Patel. Lordships want the citation, my lords, again?
It's okay.
It's on my file itself, my lords. I'll place. 133, 135 says, my lords, that you have to, that the order must disclose that you have dispensed. Right, my lord? The other argument, my lord, this without prejudice argument is self-destructive. Why? Their overarching argument is Article 311 protection is not available. You will dispense with an inquiry only in a case of an employee when Article 311 is available. The second proviso, my lords, will apply to an employee who is entitled to the protection under 311. If, my lords, 311 is not applicable, my lords, I ask myself, why should you even dispense with? For all you care, 311 is not applicable, my lords. Go home. I don't have to dispense with the inquiry under 311 too. So that's why, my lords, I started my argument, my lords, saying that the stand of the state here, my lords, is very disappointing. The decision maker is self-contradicting itself. If, may I just give, if I have to decide, my lords, I know what I have decided. I will know that I have not given you a hearing. Why? That Rule 19.2 does not provide for a hearing. That's my understanding. I may be right, I may be wrong. Your lordships will test it. It cannot be that today they say first disclosure is 19.2 does not envisage a hearing. Secondly, they say an additional affidavit as probationers we can throw you out without a hearing. You have no right. Thirdly, they say 311 is not applicable. That's the main argument. Fourthly, by without prejudice argument, they brings in, my lord, 311.2 proviso, which is self-destructive. If 311 is not applicable, 311.2, why should you even invoke for all you can? Now, my lords, in the arguments before the division bench, my lords, now the state comes up with another theory, my lords. Not pleaded. The argument made before your lordships was it would be an empty formality. It would be an useless formality. That is why we did not give. If a hearing would have been given, it would make no difference. Lords, it has to be pleaded, my lords. Give me. So, 1987, 3 SCC. That judgment, this one. Yeah, give me 2 points. Well, let's. This, your lordships will record, my lord, is not pleaded anywhere. It is not argued before the single judge. There are 2 affidavits, my lords. The affidavit in opposition. Monty, will you send Ankit also?
My lords, that's an incorrect submission. It was argued before the single judge. There is a finding by the single judge, observations by the single judge in the impugned judgment.
Please point out, I may be wrong. Please point out.
It was argued before the learned single judge.
I may be wrong.
No, that's what I'm saying.
The issue is this, my lords. Subject to correction, my learned friend says, my lord, it was argued. There is no finding by the single judge. Your lordships will just record. Single judge says promptitude, namely urgency. So the promptitude of the case did not deserve a hearing. That's the finding of the single judge. My friends are not in appeal, my lords, against the single judge order that the single judge did not render a finding that this is an empty formality. Now, please see the single judge order. Does it record? We didn't find. Ankit, you will correct me during the course. If I am wrong, you can correct.
I will try to give the specific para. I'll try.
I'll be waiting for it. Now, my lords, the other aspect is pleadings are silent. Pleading says no 19.2 hearing because hearing is not provided. There is no argument that if a hearing would have been given, it would be an empty formality or a useless, futile exercise. That the decision maker knows, my lords. The decision maker will say that no, I did not give you a hearing because it will be a futile exercise. Facts are so apparent, facts are so disgusting that we have dispensed with the hearing. And this happens in cases, my lords, which are extremely, my lords, which pains the conscience of the court or the authority. There's the case, my lords, of Hiranath versus that medical college case, my lord, where the boys went to a girls' hostel, my lord, a very old case of principles of natural justice. And they stripped themselves naked, my lords, there. So the court said that no hearing. They were rusticated from by the college. Saying, no, what hearing is required here? The facts are so blatant, facts are so disgusting, facts are so obnoxious. But is this a case like this? They are appointed under a regular appointment process. That process is not cancelled, my lords. Though they have said it's a colossal fraud, that process is not cancelled. Officers are still working. So, my lord, for the state to say, and how is it, my lords, in useless formality? I beg to ask them, my lords, how is it useless? What are the blatant facts here? Everything lies in the realm of an investigation by the police. Now, my lords, in the criminal trial, all these accused persons are entitled to the due process. They will be entitled to the trial. The prosecution will have to prove to the hilt beyond reasonable doubt. I was saying, my lords, that in the criminal trial, my lords, all the appellants who have been prosecuted will get the due process of the protection under the law. They will get, my lords, the protection available under the CRPC and the Evidence Act. The prosecution will have to prove the case beyond reasonable doubt in the criminal case. But here, my lords, they have been condemned unheard by a stroke of pen.
Continue to.
Lordship, I am available on VC Lordship.
Yes.
And just before Lordship, my colleague continues, we've already pointed out to Arnab, my colleague, that Ashok Sonkar was not only argued, it is part of the compilation, it is also part of the written submissions filed before the learned single judge, internal page 14 of our written submissions. So just wanted Lordship to be aware of that.
No, that's. As I was pointing towards, my lords, the shifting stand of the state. It is not only shifting, my lord, it's contradictory. And as I said, my lord, my learned friend, Mr. Mishra, my lord, used the word confusing. Now, my lords, as the decision maker, my lords, it is the decision maker's domain, my lords, on the basis of which, my lord, the decision has been taken. It may be right, it may be wrong, that your lordships will judge. So the decision maker, my lords, in the first blush says Rule 19 does not entail a hearing. Additional affidavit says, my lords, that as probationers, you have no right of hearing. You have no right. Additional affidavit, my lords, makes a contradictory without prejudice argument that in any event we have dispensed with. I have told your lordships, my lords, dispensing with an inquiry is qua an officer against whom Article 311(2) protection is available. You can only dispense with once the officer comes within the domain of Article 311(2). So this again is a self-contradictory. Now, my lords, the argument my learned friend, my lords, took labor to argue was that the hearing would have been an useless formality or an empty formality. Judgments were cited before your lordships. Not pleaded anywhere. My friend, my lord, has said that this argument was taken. He is also clear now that this is not in the pleadings. Their case is, my lord, what Mr. Kohli also said, was it was argued before the single judge. We do not know, my lord, the judgment does not record. No such submission, my lords, of an empty formality or a useless formality principle has been recorded by the learned single judge. They are not in appeal, my lords. They have not challenged that the High Court should have, single judge should have applied the useless formality test to say that a hearing in any event would have been a useless formality. Well, you can't play ducks and drakes with the court. Well, I started off in my opening submissions also. This is not a game of chess. the state, my lords, must be fair. And as I started my reply arguments was that the overarching, my lords, foundation of the state's action is that these bunch of 59 officers have no right. No right of theirs have been infringed. No fundamental right has been infringed. I will make it good, my lords. If an action is arbitrary, my lords, E.P. Royappa principle, my lords, that arbitrariness and discriminatory, my lords, discrimination are sworn enemies. One belongs to the rule of law in a republic, the other in the whims and fancies of an absolute monarch. And then Justice Bhagwati goes on to say, my lords, when an action is arbitrary, it is expressly discriminatory and hence violative of Article 14. What else is required, my lords? And the state says no fundamental right is affected. Article 14 is impacted, my lords. My right under Article 16(1) is impacted, fundamental right. My right under Article 21 has been affected because it's my livelihood, my lords. My friend, my lords, relied upon paragraph 44 of Tulsiram Patel on that public interest, public post, integrity of the post, and public trust. I will make good that argument on a separate compartment. But Tulsiram Patel, the lordships will see, was on 11 July 1985, the judgment came, my lords. A day prior, on 10 July 1985, the Constitution Bench judgment, my lords, in Olga Tellis came, my lords, where the lordships recall, those are the street hawkers, my lords, who were removed. Justice Chandrachud read, my lords, that the right to life is not mere animal existence. Right to life includes livelihood. And that, my lords, has been, my lords, that pedestal has been raised further in Delhi Transport Corporation case, Constitution Bench again, saying that it is not at the whims and fancies of the persons in authority that an officer, my lords, can be condemned and devoid of his livelihood. The Supreme Court says, my lords, it is ultimately public employment, my lords, which is the largest employer, my lords, in our country. And for a state to say that we can hire and fire anyone, my lords, no livelihood is impacted, because livelihood only of the family is impacted, my lords, is not tenable. I'll come to that. Now, my lords, the pleadings, the lordships will take it, my lords, even Ankit Roy, my lords, agreed with me that in the pleadings, there is no submission, not even a whisper that this would be an empty formality. And this is important, my lords, because pleadings forms the foundation of a party's case. My lordships, as I said, my lords, has also my lords, practiced in the civil side, my lords. Pleadings, my lords, ultimately is everything, my lords. Parties come before court, the pleadings are there. In that aspect, my lords, will your lordships have, my lord, 1987, I've just handed over that judgment, my lord. 87 3 SCC. 711, my lord. A judgment, my lord, I very often cite, is straight away, my lords, come to these lines, my lords, at page 718, para 11. It's stating the obvious, my lords, but I want to state, my lords, to highlight the conduct of the state here. Para 11, my lords, at page 718. I am reading, my lords, 4 lines from the top, 5 lines from the top of 11. Both the authorities, your lordships have that, my lords, have failed to bear in mind that pleadings of the parties forms the foundation of their case. And it is not open to them to give up the case set out in the pleadings and propound a new and different case. So what is the state doing here? At every stage, my lord, I shudder to think, my lord, if this matter goes to the Supreme Court, what will be their stand there? At every level, my lord, that stand is changing.
I think this is an appropriate moment to ask you a question.
Yes, my lord.
Doesn't not relevant for this matter.
Yes.
But since you have raised that issue,
yes, ma'am. I understand when I make an argument, my lords, on I am aware, my lords, of your lordships, both your lordships' experience.
No, but it's nothing to do with this.
Yes.
So I don't need an immediate reply. But
Yes,
anytime, if you can.
I will also, my lord, get back to your lordships on section 2 of the evidence act, my lord, that I have already compiled, my lord. I'll give you a lordships for more.
Okay. You have seen that?
Yes. That event, it was deleted.
it was deleted, and then
There's a
according to my,
specific act which deletes it, man.
it says that British law would be the what is
The
it?
law is applicable in British India. British
Shall apply.
Shall apply. That was deleted.
That was deleted, and therefore I take a view that only after that the laws of India became paramount. CPC.
I have it, man.
You have it?
Yes. I dare not stand before this court, man, without the CPC.
I have a very bad reputation.
That's very good, man.
And thank you for reminding me.
No, well, that's very good.
You see, first is 141.
Yes, yes. That to read proceedings, man.
Yes.
Yes.
Procedure provided in court in suit shall be followed as far as made applicable in all proceedings in civil court. Now it excludes 226.
Yes, madam.
Correct.
Yeah.
Now, please come to Order 6, Rule 1.
Yes, madam.
Pleading
Pleading
means
shall mean the plain or
written statement.
Even replication is not part of.
Not a part of
So
pleading.
that's why, my lord, replication is always with leave of the court.
Yes, we
always
understand
speak
that.
leave.
Order 8 Rule 9.
Yes.
Now the query is that because you see, the principle is borrowed from the Civil Procedure Code, where it is said that writ petition and writ petition are otherwise excluded. So therefore, would in stricter sense, so this concept of pleading applies in a writ petition, because the judgments which I found
Yes, yes.
is to the context of evidence, saying that once statement is made.
Evidence beyond pleadings cannot be looked into.
No. That principle comes in because it says that whatever statement is made in a writ petition or in an affidavit of opposition, since it is formed by way of an affidavit, it becomes partakes the character of an evidence.
I will place that judgment. There's a judgment of the Nagpur bench also. It says it partakes the character of an evidence.
Even I have authored judgment to that effect.
My argument by relying on my lord Surjit Vinod Kumar versus Surjit Kaur is
no. I'm not seeking answer right now. Just to clarify this point.
I'll do that. I'll do that exercise.
Not in this matter.
Yeah, I understand that. It's always challenging, my lord, for lawyers to look into aspects, my lord, which we normally don't look, my lord. Like Section 2, my lord, we had not looked into in the manner which a law says put that query of Evidence Act.
So because this question arose when I was reading the judgment of Subramaniam Swamy.
Yes.
It's a
defamation, that 499,500. Yes,
maybe that it was a larger bench decision where it says that, I think it was a constitution bench decision, which says that the common law of England will apply. So that gave me got a query that why that would apply when Section 2 excludes that.
In fact, my lords, the Madhyamam, the judgment which I cited, my lords, of Justice Chandrachud, that also records at paragraph 48. Why, my lords, we follow the English common law? Because they say that our judicial systems are based on that English system.
No, based is one thing, but you see, so far as in the between the bar and the bench,
yes,
at least I am not trained in English laws. Therefore, to borrow a principle without knowing, actually reading it,
yes,
without being what you call having an in-depth knowledge,
yes,
and then to decide by applying, because I would not know precedent which is good precedent and which is overruled precedent.
That your lordship is right. But my lords, what in that Madhyamam judgment which Mr. Mishra placed on seal cover, para 48 says Indian courts have been significantly influenced by the courts in England on the interpretation, application, and content of natural justice, primarily because the principles are derived from the common law and are grounded in the rule of law. The jurisprudential developments across other common law jurisdictions relating to principles of natural justice usually, if not always, spill over to the Indian jurisdiction. Our courts were soon to follow suit when the courts in England made a functional distinction between executive and non-judicial.
But this concept of this in the Hasbury laws of England, the rule of law, concept of that hearing, I don't think it's very easy to understand.
Right.
It gives reference to so many footnotes.
So many footnotes.
So by the time you read one chapter, you are exhausted.
And footnotes are always small, man. So it's a strain to your eyes also. So
That's right.
I was, my lords, on
Yes.
the conduct of the state. And that para 11, which I read, my lord, I'll read out again. That pleadings forms the foundation of their case, and it is not open for them to give up the case set out in the pleadings and propound a new and different case. Then your lordships will not permit the state, my lords, here, who is trying, my lords, with my respectful submission, to play truant with the court. They are at every stage, my lords, improvising their case. And as a decision maker, my lords, they cannot be allowed. It is your lordships today have decided that you have no right to be heard. So your lordships will say it. Rightly, wrongly, my lord, that will be tested maybe before a higher court. But for your lordships to say again tomorrow that no, it will be an empty formality. So, my lords, the shifting stand of the state, my lords, in my respectful submission, is mala fide. This, my lords, is malice in law, not in fact, my lords. My learned friend strenuously argued that mala fides, my lords, can't be against the state. This, my lords, is malice in law. Malice in law, my lords, I will place those decisions that if an authority, my lords, misapplies the law to the detriment of a citizen, that is, my lords, mala fides in law. The officer concerned may not have, my lord, any personal angst or mala fides against the officer, but since he misapplied the law to the detriment of the citizen, my lords, that is malice in law. With that respect, now just have volume 4, my lords, of the compilation I had handed over, my lords. It's a short compilation. First, my lords, paragraph 111. Very small. As like all good things, my lord, it has to come to an end, my lord. We'll end today.
But what do you call, height-wise, it is nearly a foot of short compilation.
Well, page 111, my lord. This, my lord, is
Volume 4.
Yes. I have given a copy to my learned friend, madam. Suzuki Parasuram Shootings Private Limited, madam, is 2018 10 SCC 707, page 106. My Lord Justice Nandi has it, madam. 106.
Yes, my
Running
sister has it.
Yes. Suzuki Parasuram Puria, madam. It's a 3-judge bench judgment. Please come straight, my lords, to paragraph 12. This is, my lords, on the litigant taking contradictory stands, my lords. Different stands in the same litigation.
This paragraph?
Paragraph 12, my lords. Lordships has that. Litigant.
Yes.
A litigant can take different stands at different times, but cannot take contradictory stands in the same case. A party cannot be permitted to approbate and reprobate on the same facts and take inconsistent shifting stands. The untenability of an inconsistent stand in the same case was considered in Amar Singh versus Union of India, observing as follows. Now, please mark this. This court wants to make it clear that an action in law is not a game of chess.
But I may not readily agree with this, although this is a it's a Supreme Court judgment, because of the fact that insofar as in the context of civil proceedings,
even in an appeal, you can take.
The law is that so far as the petitioner is concerned, plaintiff,
Yes.
he cannot take an inconsistent stand because the other side must know how he is to defend himself. But insofar as the defendant is concerned, he is permitted to take contradictory stand.
He can take one stand, he can take a without prejudice another stand, but that's in a civil dispute. But when it comes to a state, I'm raising the bar further. The state has to be fair, A state, cannot be expected. The state is not a plaintiff or a common litigant, taking stands in an adversarial case. Just see this, this court wants to make it clear that an action at law is not a game of chess. A litigant who comes to the court and invokes jurisdiction must come with clean hands. He cannot prevaricate and take inconsistent stands. A similar view was taken in Joint Action Committee of Airline Pilots. Please see 12. The doctrine of election is based on the rule of estoppel. The principle that one cannot approbate and reprobate inheres in it. The doctrine of estoppel by election is one of the species of estoppel in pairs or equitable estoppel, which is a rule in equity. Taking inconsistent pleas by a party makes its conduct, please mark this part, far from satisfactory.
Here also it is the same thing.
Yes.
Which I was referring to, because what happened was this company was proceeded with for for liquidation in the company proceedings.
Yes.
And then he was also proceeded in the surface here. So when he approached, that means he becomes the petitioner.
Yes.
And therefore for the petitioner it's impermissible. But for the respondent, I'm not sure.
Your lordships will test it. When the respondent is a state.
No, you take note of your submissions.
But a state, who is the decision maker here, They know what their decision is based on. If I have to take a decision, I will tell your lordships that this is my decision. I chose not to hear them because Rule 19 does not enable them a hearing. Your lordships will test it, whether Rule 19 enables or doesn't. I cannot then come and say that no, the hearing would have been an empty formality. Then, your lordship is right. That should be pleaded. You have to plead. They should have pleaded that yes, your hearing would have been with a formality. As I told your lordship, that case of Hiranath Mercer versus that medical college, where the students were rusticated. The facts are so reprehensible. Courts will say yes, hearing is a. Look at the facts here, We were appointed in service, albeit as a probation. Our service record is impeccable, There is not a single allegation against any of the officers that they underperformed during the probationary period. The discharge orders, are not based on any satisfactory performance or non-performance by the officers. It's a misnomer, my learned friend argued, that the discharge orders are not stigmatic. It is based on the non-satisfactory performance. That's not what the discharge order at 249 says. And my respectful submission is, such contradictory and shifting stands, that too from the state respondents, is an impermissible volte-face, They are trying to, from here they're swinging, Your lordships will not permit them. And there's change of stands, discloses their malafide. They have not acted bona fide. Now, in that respect, when your lordships has this compilation, please come straight, to malice in law. That the initial judgment, is Venkatraman, 79 Supreme Court, but that's followed in a later judgment by Justice Nageshwar Rao, in X versus High Court of MP, Before that, will your lordships have page 64, SR Venkatraman. Page 65, your lordships have, this is 1979. 2 SCC 491. But this is the original judgment of Justice Singhal and Justice Chinnappa Reddy, where it explains what is malice in fact and malice in law. These are cases of malice in law, my lord, not malice in fact. We are not saying that the officer concerned had a personal animosity against us. But their illegal actions, my lords, have resulted, my lords, in a malified exercise of power. But I was referring to, my lords, paragraph 5 at page 64. Notice have paragraph 5, my lords?
Yes.
Yes. Page 64, my lord. I'm paragraph 5, I'm reading the last two lines. Malice in law is, however, quite different. Viscount Heldon described it as follows in Shearer versus Shields. A person who inflicts an injury upon another person in contravention of the law is not allowed to say, please mark this, my lord, he did so with an innocent mind. He is taken to know the law and he must act within the law. He may therefore be guilty of malice in law, although so far as the state of mind is concerned, he acts ignorantly and in that sense innocently. So look how beautifully it's explained, my lords, that a person who inflicts an injury upon another person in contravention of the law is not allowed to say that he did so with an innocent mind. He is taken to know the law and he must act within the law. He may therefore be guilty of malice in law, although so far as the state of mind is concerned, he acts ignorantly and in that sense innocently. Thus, malice in its legal sense means malice such as may be assumed from doing of a wrongful act intentionally, but without just cause or excuse, or for want of reasonable or probable cause. Then let's para 8, my lord, after my lords, highlighting the law, para 8, we are in agreement with this view. It is equally true that there will be an error of fact when a public body is prompted by a mistaken belief in the existence of a non-existing fact or circumstance. This is so clearly unreasonable that what is done under such a mistaken belief might be said to have been done in bad faith. Might almost be said to have been done in bad faith. But in actual experience and as things go, there may well be said to be run into one another. So, my lords, in this case, my lords, the fact that they proceeded that Rule 19 does not visualize a hearing is, my lords, in my respectful submission, malice in law. And this, my lord, this aspect has been further explained, my lord. Just have the next judgment, my lord. 2022 for Justice Gawai, my lord, 2022 14 SCC 187 at paragraph 60-61. Page 93.
On same proposition, malice in law.
Yes, my lord, malice in law. So, my lords, here, my lords, where the officer discharged, my lords, these officers, he acted in malice in law because he did not, my lords, apply the law. Not in bad faith, but the court says ignorance of law is no excuse. He is bound to know the law. And if it causes an injury, my lords, then that is malice in law. Please have page 93, para 60. In the context of the state, my lords, just have, my lords.
Paragraph
60 at page 93, running page 93, my lords.
60.
Yes.
Yes.
We may gainfully refer to the following. Lord Justice Nandi has it.
Yes.
We may gainfully refer to the following observations made by this court in Kalabati Advertising versus Hemant Vimalnath Narayanchana. The state is under obligation to act fairly without ill will or malice in fact or in law. Legal malice or malice in law means something done without lawful excuse. It is an act done wrongfully and willfully without reasonable or probable cause, and not necessarily an act done from ill feeling and spite. It is a deliberate act in disregard to the rights of others. Where malice is attributed to the state, please mark this, Milad, it can never be a case of personal ill will or spite on the part of the state. It is an act which is taken with an oblique or indirect object. It means exercise of statutory power for purposes foreign to those for which it is in law intended. It means conscious violation of the law to the prejudice of another. A depraved inclination on the part of the authority to disregard the rights of others with intent is manifested by its injurious acts. 61, it is tried that the state is under obligation to act fairly, without ill will or malice in fact or in law. Legal malice or malice in law means something done without lawful excuse. It is an act done wrongfully and willfully, without reasonable or probable cause, and not necessarily an act done from ill feeling and spite. When malice is attributed to the state, it can never be a case of malice or spite on the part of the state. It would mean exercise of statutory powers for purposes foreign to those for which in law intended. It means conscious violation of the law to the prejudice of another, a depraved inclination. So it repeats the words. So my respectful submission is, my lords, when the officer concerned, my lords, took the decision to discharge, my lords, the appellants. In my case, my lords, the appellant in writ appeal number 14 of 2022, he acted, my lords, malified, and that malice is malice in law. Now, my lords, the third argument, and on that natural justice aspect, I must point out that pleadings I have shown, the single judge, my lords, at para 52, dehosts the pleadings, now comes to a finding of promptitude and urgency. Well, these are all side winds, my lords, to deny a hearing or the principles of natural law. Single judge says, my lords, that there was urgency in the case, that there was immense promptitude required to act against these officers who were implicated in Dibrugarh police station case, and therefore, my lords, hearing was not imperative. That's the finding of the single judge at paragraph 52, page 452. I already placed that, my lords. Now, my lords, this finding, my lords, in my respectful submission, is negated, my lords, from the records of the case. And if your lordships, my lords, there's a written submissions besides your lordships, I'm sorry, my lord, it's turned out to be a bit thick, but my apologies, my lord, but I tried my best, my lords, to capture the arguments. My apologies. I really sincerely apologize. I tried my best, my lord. At the end, I asked my stenographer in Delhi that, can we do it? Can we further make it small? He says, not possible. That's paragraph 3.
Now you have tools to shorten it up.
But those tools, my lords, those tools are dangerous, my lords.
On a lighter note, Lordship, we are trying to keep it to 1/3 of what my learned friend has put down. So I thought tools are not tools. Our challenge is how do we reduce it with he's written a very, very good detailed one.
I'll give it to my learned friend straight away, my lords. He has the gift of
But of course, Lordship, I will need time till tomorrow morning, first thing to give it. We will give it today evening. We'll finish it today evening.
Credit, I give it to him, my lords, straight. Now, let's please have
Great.
3.2 at page 10, my lords. Lordship says that, my lord. Page 10.
You know the best fallout.
Yes, my lord.
With the hearing of this on day-to-day basis, now my what you call this?
Disposal is
my hairdresser. He says that, sir, you don't have any need to come here. Your headline is just falling without his help.
Lordship may have also, in a sense, spoken about my status.
No, I can speak of myself.
No, but Lordship has ended up confirming what my situation is too.
So, I was at para 3.2 at page 10. Our apologies, my lords.
No, not
burdening your lordships, my lord.
No.
I really tried my best, my lord, but I couldn't give up any point.
This is something I always do to keep my mood in a.
No, it's always good, my lords. The atmosphere is, my lords, lighter.
I try to You try to get an opposite
Yes,
smile.
your lordships, I've seen it, my lord. Tremendous patient. Even in the Nagaland case, I was noticing, my lords. It was not ending. But after reply, another reply, then another one. Till your lordship says that for the hearing in July.
No, because otherwise this would have
I
affected.
understand. I saw that. But lordships have 3.2 at page 10, my lords. The underlined first 3.2, the only rationale for promptitude to dispense with the principles of natural justice, as per the learned single judge, please mark, my lords, is the disturbing disclosures in the investigation report with regard to prevalence of unfair procedure and tampering of the examination process for the benefit of the petitioner. If this has happened, my lords, this has happened way back in 2013-14, when the examination took place, my lords. What is the promptitude, my lords, in 2018? Everything was documentary in nature. Now, please see much further, my lords. The alleged disclosure in the investigation report could not have been relied upon, and in any event could not be a ground for urgency to dispense with the principles of natural justice. Please mark, my lords. The FIR in the present case, Dibrugarh PS case, was registered on 27/10/16. Examination of 2013-14, my lords. The appellant was arrested on 18/7/18 and released on bail on 11/10/18. The supplementary charge sheet number 6 was filed on 14/9/18, wherein the appellant was arraigned as accused number 54. Therefore, the discharge order passed on 21/1/19 after over 4 months of the filing of the supplementary charge sheet and over 6 months from our arrest cannot be said to brook no delay so as to dispense with the fundamental principles of fairness and justify the passing of an ex parte unilateral order. It is not something, it's something which happens on the spur of the moment. Your lordship says, okay, go, out you go. Because we need to act promptly. Like those students, my lords, those boys who went to that girls' hostel, my lords, stripped themselves naked. Principal rusticated them immediately without principles of natural justice. Said that no. What you have done is reprehensible. In front of us, we'll not allow this to happen. That's different thing. Here, my lords, please see. Where is the promptitude, my lords? I ask myself. This promptitude, my lords, in my respectful submission, is a finding of the learned single judge. Without any material. And this finding, my lords, is an error apparent on the face of the judgment. Where is the promptitude here, my lords? If at all, my lords, I have conducted any such, my lords, that I entered the service, my lords, illegally by committing some unlawful act, that happened in 2013-14, my lords, when the CCE 2013 and 2014 was conducted. Now, my lords, the other argument which my friend wrote, my lords, that was also an overwhelming argument of my learned friend, was he used the word taint. That these appellants are a bunch of officers who are tainted. In the additional affidavit, my lords, this word is introduced saying that they are tainted. In my respectful submission, my lords, who has decided I am tainted? The Dibrugarh police station case? My being implicated, my lords, in a criminal case? My being arrested in a criminal case? Which is pending trial today? And my respectful submission is, my lords, the use of the word taint reverberates, my lords, in the additional affidavit and in the arguments of my learned friend, my lord, throughout in this proceedings before this court. And that itself is stigmatic. If, my lords, my learned friend says I am tainted, my lords, she has demeaned my character. It's a stigma straight away, my lord. A gentleman is tainted. If there is a taint on my white shirt, my lord, it means my shirt, my lord, is tainted. And the dictionary meanings, my lords, I will not trouble your lordships. I've taken out all the dictionaries available in my dad's chamber. And I'll just refer to the best definition, my lords. Which one? Of volume 4, my lords. Just see the definition of what taint and stigma. My lords, the lordships will just note taint is a stigma. Nothing else is required. Page 225, my lord, this is New Webster's Dictionary of English Language.
Page number?
223, it starts, my lord. Stigma. First, my lord, please have the definition of stigma at page 224. And as your lordship said, my lords, that even in writ proceedings, since pleadings are part of an oath, the lordships will look into the pleadings. And the pleadings of the state, my lord, itself is stigmatic. Nothing else is required. They have, my lord, described us as tainted officers. Who has decided we are tainted, my lords? The registration of the implication in the Dibrugarh police station case. Nothing else. Otherwise, my lords, our record, service record, my lord, during the probationary period, and I speak for each of the officers, are exemplary. They are very good officers. There is nothing to show that our services were unsatisfactory. Nothing, my lord. Rather, my lord, they have got accolades in the. My client has an accolade, my lord, saying that satisfactorily completed her training. Now, my lord, please have page 224, my lord. Stigma. Lordship said that, my lord. Your ladyship has page 220. I'm on the left-hand side, my lord. Stigma is somewhere, my lord, after stifle. Stigma. A prick with a pointed instrument. Any mark of infamy. Please mark this part. A blemish or a stain. As on one's character. Obviously, my lord, we have been branded as stigma, as tainted. We've been thrown out of employment. We have been socially castigated. A brand of disgrace, please mark this. It's a disgrace on us. Attached to a person. A natural mark on the skin. Lordship will skip that part. And please come, my lords, to page 225. Taint. I have given, my lords, the law lexicon meanings also, but I'm just giving one example. My lords, page 225. Taint. Lordship has it on the right hand side.
Yes.
Taint, finger, to wet or moisten, whence also taints. To imbue or impregnate with something noxious, poisonous, or offensive. To infect, to corrupt, to sully or pollute. Our image has been sullied, my lords, as one's name or honor, to become infected, corrupted, or contaminated. Any trace of that which is bad, harmful, or offensive, something that infects or contaminates, infection, corruption, stains. Because the pleadings itself, my lords, where, my lords, these officers have been branded, my lords, as tainted, is, my lords, in my respectful submission, stigmatic. And this aspect your lordships will find, my lords, in, my lords, that volume 4 which your lordships have, my lord, at page 199. On page. This volume 4. Malti. Dadaji Mahajan, my lord. There's a Nagpur bench judgment, my lord. This also, my lord, was a case, my lords, of termination of employment without, my lords, following the principles of natural justice. And if your lordships come straight to paragraph 16 of this judgment, page 205. Lordships has that, my lord? running page 205. Page 205, paragraph 16. Keeping in contemplation all the rules and the principles stated above before us, we may proceed to examine the present controversy in the light of the pleadings which are sworn statements of the respective parties. To find out whether the order of termination is a cloak or a pretext to dispense with the need for inquiry, we're entitled to see what the parties have averred in the respective pleadings. So they're looking into the pleadings here, the court. In the writ petition proceedings, these pleadings are admitted as basic evidence. That's what Lordship said, Melats. These are statements on note and can be acted upon as such. We have already made a reference to the order in each of these cases. The petitioner in each case averred that her record of service was good, and in spite of that, she was been subjected to termination. It is further stated that she was been subjected to dismissal. As against this, in case the return has been filed on behalf of Jila Parishad by the Chief Executive, in the case of Malti Mahajan, the petitioner in the first petition, the return asserts that the petitioner has suppressed material facts from the court. Then it goes on to say that on June 24, it was found from a report, please mark, that the petitioner's work was unsatisfactory. In 1968, the petitioner disobeyed the orders. She was fined ₹15. Thereafter, her work was inspected in 69, found that she was remiss in maintaining the registers, and therefore she was fined of ₹20. Inspection was held in 1970, and the petitioner was found absent from so and so. Please turn the page, page 206. 17. These statements contained in the return unmistakably indicate that the termination of the petitioner, Malti Mahajan, was clearly founded on the grounds of her conduct. So here, pleadings are galore, pleadings of taint. The submissions, throughout, which reverberated was that these officers are a group of tainted. Reading all these paragraphs together leaves us in no doubt that the termination is based on the conduct of the petitioner, Malti Mahajan, in the matter of her service, involving her in charges of making false record. Please mark this, and report as well been negligent. We have no hesitation in holding that the termination being so connected with the behavior of the petitioner, the Parishad or the competent authority is not absolved from the obligation to follow the prescription of Rule 6. Such a termination, in our view, would amount to removal or dismissal for service. To impose that penalty, the procedure required by Rule 6 would of necessity be followed. Then it refers to Vimal Moge case, all identical things, till 21. So pleadings are looked into by the court, because the Lordship says these are ultimately solemn affirmation. And the state's pleadings, one thing is common in the state's pleadings, though they have shifted stance from the additional affidavit, their case is we are a group of tainted officers. This itself is stigmatic, we did not go anywhere else. So the reason for discharge of the petitioners, the appellants herein, is the Dibrugarh police station case, which, according to the state, renders these officers tainted. Taint is stigmatic in its very nature, One is tainted means there's a stigma cast upon you. And your Lordships will look into the pleadings, to see, whether, does it cast a stigma? Answer is yes. Does it, is it punitive? Yes. And how is it punitive? The test is, will it impact his or her future employment prospects? Answer is yes. Now that useless formality principle, because this is argued for the first time before your Lordships. Though my learned friend says, this argument was made before the single judge, it's not recorded anywhere. On the point of useless formality test, my understanding, my submissions are this, that state has not disclosed why would it be a useless formality, because this is an exception, to the rule of hearing, the rule of natural justice. If you want to exclude the hearing, state will have to give cogent reasons. How is it, an empty formality? What are those glaring facts on the basis of which, the hearing would make no difference? It is not disclosed. You just can't argue, on the law. Now on that useless formality test, my lords, please have, my lords, my written submissions, my lords. I have not written submissions, my lords, and the compilation I have handed over, my lords. Please come, my lords, to page 39. I've given excerpts of the weight principle, the weight, my lords, on administrative law. If your lordships come to page 40, where a fair hearing would make no difference. My lord, this argument I am making, my lords, without prejudice to my primary contention that there is no pleadings. State should have disclosed, my lord, the decision. Let's see, my lord, where a hearing would make no difference. Procedural objections are often raised by unmeritorious parties with a weak case. Judges may then be tempted to refuse relief on the ground that a fair hearing would have made no difference to the result. But in principle, it is vital that the procedure and the merits should be kept strictly apart, since otherwise the merits may be prejudged unfairly. Lord Wright once said, if the principles of natural justice are violated in respect of any decision, it is indeed immaterial whether the same decision would have been arrived at in the absence of departure from the essential principles of natural justice. The decision must be declared to be no decision. On another occasion, sadly, Lord Justice said, even judges found it seductively easy to conclude that there can be no answer to a case of which you may have not heard one side. The dangers are vividly expressed by Maguire Justice in criticizing the contention that the result is obvious from the start. Will your lordships, my lords, have volume 1, my lords, of my compilation, my lords, volume 1, which I initially gave, my lords. There's one judgment I had kept it on for reserve because I was anticipating that an argument of this nature may be taken. Volume 1, my lords. This is that Justice Maguire, my lords, which is quoted in Wade. John versus Rees. My lords, this judgment starts at page 42. At 83. And this is followed, my lords, even in S.L. Kapoor versus Jagmohan. Supreme Court follows this dictum, my lords. Page 83, your lordship says, my lords.
Page 42.
Page 83. The judgment begins at 42. At 83, your lordship said. May I read, my lords? Just below placetum D. D for Delhi, my lords. It may be that, your lordship says that. Below placetum D.
Yes.
It may be that. Ladyship has it, my lords? Yes. It may be that, I'll read it slowly, my lords. This is a very good reading, my lords. It may be that there are some who would decry the importance which the court attaches to the observance of the rules of natural justice. When something is obvious, they may say, why force everybody to go through the tiresome waste of time involved in framing charges and giving an opportunity to be heard? The result is obvious from the start. Those who take this view do not, I think, do themselves justice, as everybody who has anything to do with the law, your lordships, my lords, have more to do with the law, my lords, well knows the path of the law is strewn with examples of open and shut cases, which somehow were not of unanswerable charges, which in the event were completely answered, of inexplicable conduct, which was fully explained, of fixed and unalterable determinations that by discussion suffered a change. Nor are those with any knowledge of human nature who pause to think for a moment likely to underestimate the feelings of resentment of those who find that the decision against them has been made without there being afforded an opportunity to influence the course of events. But they are saying unanswerable charges have been explained, my lords. That's the law. Inexplicable conduct has been explained. That's the beauty of hearing, my lords. That's the beauty of the due process. And here, my lords, the state without any pleadings now orally argues that it would be an empty formality. Now, my lords, your lordships also have S.L. Kapoor, my lords, that's in that volume 4, my lords, page 379. During the argument, my lordships put a query to Mr. Kohli, my lords, on S.L. Kapoor is a 3-judge bench, my lords. How can a 2-judge bench, my lords, restrict, my lords, the flow of the judgment in S.L. Kapoor, my lords? Please come to S.L. Kapoor, my lords.
December.
This S.L. Kapoor, my lords, is page 43 of this compilation.
This is on same principle, point of useless formality.
Yes. But para 17, if your lordships have money. I'll just place it, and your lordships will just note it, Malad. Para 17 at page 56. Para 17, your lordships have, Malad.
Yes.
Page 56. Linked with this question is the question whether the failure to observe natural justice does at all matter if the observance of natural justice would have made no difference, the admitted or indisputable facts speaking for themselves. Where on the admitted or indisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible, the court may not issue a writ to compel the observance of natural justice, not because it approves the non-observance of natural justice, but because courts do not use futile writs. But it will be a pernicious principle, please mark this, Malak, to apply in other situations where conclusions are controversial, however slightly, and penalties are discretionary. So in this case, Malak, the lordships have also seen, Malak, that there is a RTI reply which says, there is no such mandate that answer sheets have to be printed in government press. All those are there, Malak. Something we have to say. Now, Malak, please see, Malak, 18 Reeds versus Baldwin is quoted, 19 Malak, that John versus Reeds, which I extract gave, Malak, and please come straight away to para 24. If the writ is futile, your lordships will not issue. That's a satisfaction which the writ court will issue, Malak, not, Malak, the deciding authority. The decision maker cannot say, Malak, that it will be a futile exercise. Just have para 24, Malak. Come to page 59. It quotes from Jackson on natural justice, and 59, Malak, the first sub-paragraph, in our view, your lordships has that. At the top, Malak, after the quotation, in our view, the principles of natural justice know of no exclusionary rule, dependent on whether it would have made any difference if natural justice had been observed. The non-observance of natural justice is itself prejudice to any man, and proof of prejudice independently on proof of denial of natural justice is unnecessary. But please mark the next part. It ill comes from a person who has denied justice, that the person who has denied justice is not prejudiced. And as I state this for the state, they cannot be heard to tell your lordships that they have not been, that it would still amount to the same, because they have denied us justice. So it says again, Malak, it ill comes from a person who has denied justice, that the person who has been denied justice is not prejudiced. As we said earlier, where on the admitted or in undisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible, the court may not issue its writ to compel the observance of natural justice, not because it is not necessary to observe, but because courts do not issue futile writs. We do not agree with the contrary view taken by the High Court. That's a decision which the writ court will take, Madam. The decision maker cannot take a decision that this will be a futile writ. That your lordships will decide. But I have said, my lords, here that it's not an open and shut case. There are much to explain, my lords. We would have explained if a notice was given.
Okay.
And that notice, my lords, in my respectful submission, is imperative under Rule 19.2. That, and my lords, these are two separate compartments. One is, my lords, under 19.2, the officer has a right to be heard before, my lords, he is discharged or terminated from service. And the other compartment is, my lords, the constitutional protection under Article 311.2. That, my lords, is available to every officer, whether he is a probationer, whether he is a temporary officer, or he is a permanent officer. Now, my lords, on that regard, my lords, please have, my lords, that Dhingra was cited, my lords. One judgment, my lords, which I must point out, my lords, and Mr. Chaudhary will also raise this judgment, is Motiram Deka's case, my lords. This is a judgment arising from, my lords, the Guwahati High Court, page 112 of my volume 4. This is a 7-judge bench decision, my lords.
Page number?
Page number 112 of volume 4, my lords. Motiram Dhingra, my lords, Purushottam Lal Dhingra was the correctness of Purushottam Dhingra was reconsidered, my lords, by the 7 judges bench in Motiram Deka. And my father tells me that he was a legendary figure. He was Dilip Hazarika's client, my lords. And Dilip Hazarika one day brought him inside the bar room and introduced to everyone, saying he is the legendary Motiram. 7 judgments. That you'll not just have page 113, my lords. Justice Gajendra Gatkar is the majority view. These two groups of appellate lordships has been. These two groups of appeal have been placed before us for hearing together because they raise a common question of law in regard to the constitutional validity of Rule 148.3 and 149.3 contained in the Indian Railway Establishment Code, Volume 1. The first group consists of 4 appeals, so-and-so, Motiram Deka and Sudhir Kumar Das, respectively, in the Assam High Court. So the judgment went from this court. Deka was a peon employed by the Northeast Frontier Railway, where Das was a confirmed clerk. They allege that purporting to exercise power under Rule 148 of the Code, the respondent, the General Manager, Northeast Frontier Railway, terminated their services, and according to them, the said termination was illegal in as much as the rule under which the impugned orders of termination has been passed was invalid. Now, please come to page 119, my lords. 119, part of paragraph 13. Lordship has been after Article 311.2 is quoted, we are not concerned with the cases covered by the proviso to this article in the present appeals. The leadership has it, I'm grateful. It may be taken to be settled by the decisions of the court, of this court, that since Article 311 makes no distinction, please mark this, between permanent and temporary posts, its protection must be held to extend to all government servants holding permanent or temporary posts or officiating in any of them. So it applies to all government servants. Then, lordship will come, skip that part. The protection afforded by Article 311.2 is limited to the imposition of the 3 major penalties contemplated by the service rules. The next sentence, in regard to temporary services or servants on probation, please mark that. Every case of termination of service may not amount to removal. In cases falling under these categories, the terms of the contract or service rules may provide for the termination of the services on notice of a specified period or on payment of salary for the said period. There is no such, that does not provide, our terms of employment does not provide notice and payment of salary of the said period. And if the exercise of the power thus conferred on the employer, the services of a temporary or probationary services are terminated, it may not necessarily amount to removal. In every such case, courts examine the substance of the matter, and if it is shown that the termination of the services is no more than discharge simpliciter effected by virtue of the contract or the relevant rules, Article 311.2 may not be applicable in such a case. If, however, the termination of a temporary services in substance represent the penalty imposed on him or punitive action taken against him, then such termination would amount to removal under Article 311 and Article 311(2) would be retracted. Let's further, let's please come to para 43. This is the 7 judges bench saying, and yesterday, Mr. Patwari placed the judgment before your lordships of Imran Borbhuya. Imran Hussain Borbhuya, where a lordship Justice Surana sitting singly has taken the view that Article 311 protection is available to a probationer. Now, please have page 40, para 43 at page 135. At the conclusion of his judgment, my lord has that. We are not in virgin territory, but your lordships have already taken the view.
No, there can also be a view that maybe I was not that learned that time. And now learned enough to change the view.
Now, at the conclusion of his judgment, the learned Chief Justice has observed that in every case, the court has to apply the 2 tests mentioned above, namely, whether the servant has a right to the post or rank, or 2, whether he has been visited with evil consequences with the kind hereinafter referred to. It would be noticed that the 2 tests, please mark my words, are not cumulative, but are alternative. So that if the first test is satisfied, termination of a permanent servant's services would amount to removal because his right to the post has been prematurely invaded. The learned Chief Justice himself makes it clear by adding that if the case satisfies either of the 2 tests, then it must be held that the servant has been punished and the termination of his services must be held to be wrongful and in violation of the constitutional rights of the servant. It would thus be noticed, please mark this part, the first test would be applicable to the cases of permanent servants, whereas the second test would be relevant in the case of temporary servants, probationers, and the like. So when you apply the second test, my lord, is whether he has been visited with evil consequences. Answer is yes. We have been castigated as tainted. We have been balanced. My discharge order at page 249 is a detailed discharge order. It itself stigmatic, my lord, refers to corruption allegations. Well, I have been, my lord. Now, please have the next paragraph, paragraph 16. Paragraph 70. 66. But 66 is from but para 66, it reiterates the view taken in Dhingra, and straight away come to para 70. Page 149, this is Justice Subbarau's concurring view, I am reading,
You refer to 66 also.
66 also, 66 reiterates, what was there in Dhingra. But please have page 146, para 66. I'm grateful to my learned friends. It refers to Article 311, and if your lordships have 6 lines from the top, the article does not expressly or by necessary implication indicate that the dismissal or removal of a government service must be of a particular category. Lordships has that, The article, 6 lines from the top of para 66. The article does not expressly or by necessary implication indicate that the dismissal or removal of a government servant must be of a particular category, as the said article gives protection and safeguard to a government servant who will otherwise be at the mercy of the government. The said word shall ordinarily be given a liberal meaning, liberal or at any of the natural meaning, unless the said article or other articles of the Constitution expressly or by necessary implication restrict their meaning. I do not see any indication anywhere in the Constitution which compels the court to reduce the scope of the protection. The dictionary meaning of the word dismiss is to let go, to relieve from duty. The word removal. In their ordinary parlance, therefore, the said words mean nothing more or less than the termination of a person's office. The effect of dismissal or removal of service from this office is to discharge him from that office. In that sense, the said words comprehend every termination of the services of a government servant. There must furthermore, there is no justification for placing any limitation on the said expression, such as that the dismissal or removal should have been the result of an inquiry in regard to the government servant. The attempt to imply the said limitation is neither warranted by the expressions used in the article or by the reason given, namely that otherwise there would be no point in giving them an opportunity to defend himself. If this argument is correct, it would lead to an extraordinary result, namely that a government servant who has been guilty of misconduct would be entitled to a reasonable opportunity, whereas an honest government servant could be dismissed without any such protection. In one sense, the conduct of a party may be relevant to punishment. Ordinarily, punishment is meted out for misconduct. If there is no misconduct, there could be no punishment. Punishment is therefore correlated. And then please have para 70. This is part of Justice Subbarau's concurring view in Motiram Dekha. Around 10 lines from the top. On that basis, page 149. On that basis, having considered the different aspects of the problem, the court has laid down the following two tests to ascertain whether the person is dismissed or removed within the meaning of Article 311 of the Constitution. 1, whether the servant has the right to the post or the rank. 2, whether he has been visited with evil consequences of the kind herein before referred to, that is, loss of pay, allowances, and loss of his seniority in his substantive rank, or the stoppage or postponement of his future chances of promotion. If an officer had a right to a post or rank, and if the termination of his services deprived him of that right, the said termination would be dismissal or removal as punishment. So too, if the termination has the effect of the officer being visited with evil consequences, that whatever may be the phraseology used for putting the end of the service, it would be dismissal as punishment. The motive operating on the mind of the authority concerned, or the machinery evolved, or the method adopted to put an end to his services are not relevant in considering the questions whether he was dismissed. If he had a right to the office, or if he had been visited with evil consequences, though the said circumstances may have some relevance, as other decisions of this court disclose, in ascertaining whether he has been discharged with a stigma attached to him, while considering that this decision does not term specifically laid down that even in case of a person holding a permanent post. In these cases, your lordship will note one thing, Miller, that these appointments of the appellants, Miller, were against substantive post by a regular selection process, Miller. In our case, Miller, these are not irregular appointments. These are not illegal appointments, Miller.
But in this paragraph which you are reading,
yes, Miller,
the last part which you are reading, while considering
that this decision does not in terms specifically lay down that even if a case of a person holding a permanent post, if there was an appropriate term in the condition of service that his services could be terminated by notice, Article 311 would not be attracted. It is contended that the reason date of the decision and some passages that it lead to that conclusion. Some of the passages are so many. It records the contentions. Then please have 151 minutes. These are contentions made before the 7 judges bench. Page 151 minutes. Before that 150 minutes, in the middle, these passages certainly lend support to the argument of the learned counsel, but the qualifying clauses on which reliance is placed are only incidental observations. The main principles relevant to the present inquiry were laid down by the court clearly and precisely at page 860. So it calls out what was the ratio decidendi in Dhingra. Then please have at page 151. This decision therefore clearly lays down, without any ambiguity, that if a person has a right to hold office under the service rules or under a contract, the termination of his services would attract Article 311 of the Constitution. It lays down that a person holding a substantive lien or a permanent post has a right to such office. It does not say expressly or by necessary implication that even if a person is deprived of such a right, it will not be punishment, unless it is inflicted for misconduct in the manner of the service. Like I said, my lords, all these appointments were made, my lords, by regular advertisement. by these are substantive appointments, my lords, against vacant existing post. These are not, my lords, irregular or illegal appointments in this sense. Now, my lords, now one aspect, my lords, which also fell from a query of this from this court was paragraph 64 of Samsher Singh. Paragraph 64 of Samsher Singh, my lords, your lordships recall that, my lords, where an inquiry is mentioned. Your lordships remember that, my lords? And your lordships asked, my lord, put a query immediately, my lords, to Mr. Kohli, which is this inquiry? Will your lordships have Samsher Singh, my lord, either Mr. Kohli's compilation or my compilation, volume 2, my lords? Whichever is my compilation lordships have, or
Yes.
volume 2, my lords, page 58, page 70. Lordships has, my lords, page 70. When paragraph 64 was placed, my lords, your lordships will see, my lords.
Just a moment. You are referring to paragraph
64 of Samsher Singh, my lords.
64.
Your lordships has my compilation, my lords.
Yes.
Page 70.
Yes.
Before a probation, lordships has, my lady has it, my lords, page 64, page 70, para 64. Before a probationer is confirmed, the authority concerned is under an obligation to consider whether the work of the probationer is satisfactory or whether he is suitable for the post. In the absence of rule governing a probationer in this respect, the authority may come to the conclusion that on account of inadequacy for the job or for any temperamental or other object not involving moral turpitude, the probationer is unsuitable for the job and hence must be discharged. No punishment is involved in this. The authority may in some cases be of the view that the conduct of the probationer may result in dismissal or removal on an inquiry. But in those cases, please mark, my lords, the authority may in some cases be of the view that the conduct of the probationer may result in dismissal or in removal on an inquiry. But in those cases, the authority may not hold an inquiry and simply discharge the probationer with a view to give him a chance to make good in other works of life without a stigma at the time of termination of the probation. If, on the other hand, that's where your lordship's query was, if, on the other hand, the probationer is faced with an inquiry on charges of misconduct or inefficiency or corruption, and if his services are terminated without following the provisions of Article 311, he can claim protection. Your lordship's query was, and I vividly remember, your lordship says, which is this inquiry? My learned friend's argument was, this is the departmental inquiry. It starts with a show cause notice, reply, charge sheet, evidence, etc. This is not, my lords, the departmental inquiry. This is an inquiry, my lords, where the employer, my lords, collects the material against the officer. In this case, my lords, when they collected the material from the Dibrugarh police station case, and this is, my lords, a prelude to the inquiry envisaged under 311. And this answer, my lords, your lordships will find, my lord, I referred to two places where they said preliminary inquiry. Lordships recall that, my lords? My learned friend did not answer, my lords, what was that preliminary inquiry? That answer, my lords, is in the judgment of the single judge at page 453. Just have that. This clinches the issue. Page 453, paragraph 45 of the impugned judgment explains which was this inquiry, my lord. This inquiry is a prelude to the departmental inquiry. This is the inquiry when the employer, my lords, collects the material and checks the veracity of the material which they got. Now, please have page 453, paragraph 45. This, my lords, is completely ex parte, my lords. I was not involved in this inquiry. They decided, my lords, to discharge us. And this, my lords, came out from the office files. This is not even disclosed by them. In the additional affidavit, they refer vaguely in two places. Preliminary inquiry. Your lordships asked me which was that inquiry. I said, we do not know. We were not involved. Now, this just a paragraph 45. 453. And this, my lords, is ex parte. And this is what, my lord, Justice Krishna Iyer said, my lords. The office files, your lordships has that, my lord?
Just one.
And this is that inquiry at para 64, my lords. The probationers, my lords, this inquiry was conducted.
Yes.
The office files, lordships has that, as indicated above, chronologically records the events taking place. Please mark, my lords, following information received from the Dibrugarh police as regards the arrest of the petitioners in connection with Dibrugarh PS case number 936 of 16. From the decision, please mark, my lords, from the decision calling for a detailed reports from the Dibrugarh police for taking further action, please mark, my lord, to receiving such reports in connection with the arrest of the petitioners, to the decisions to withdraw the services of the petitioners pending action to be taken by the Personnel Department, Government of Assam, to obtaining the views of the Judicial Department before taking final decision, and to obtaining the approval accorded by the Chief Minister of Assam, together with the views of the Advocate General Assam, before the petitioners were discharged from service by orders of the Governor of Assam. The same finds recorded in the respective office files. This was completely ex parte, my lords. No notice and not even disclosed. Not even disclosed, my lords, in the affidavit in opposition or in the additional affidavit. What the Honorable Judge culled out from the office files that there was one inquiry which was done. This was a discrete inquiry done behind my back, on the basis of which, my lords, the entire decision to discharge me was taken. Now, my lords, can they say, my lords, still that this is not a stigmatic order? That the decision, my lords, was not based on the police case? That's the primary factor, my lords. The taint is, my lords, the police case. Now, my lords, this, my lords, the Supreme Court has said, my lords, that even in this preliminary inquiry, the officer has a right to be heard. If you are conducting such a discrete inquiry, you can't do it. That's, my lords, High Court of Gujarat versus Jayashree, my lords, 2013, 16 SCC, page 59. That's part of my compilation, my lords. Just record the page number. I will not read it, my lords. 2013, 16 SCC, page 59. Your lordships will come to para 31, 32 at page 312 of this compilation itself.
Of this compilation?
This same compilation, my lords, where your lordships had, my lords.
Volume 2.
Yes, volume 2.
Page number?
This judgment, my lord, starts at page 292 at this was the High Court doing, my lords, a discrete inquiry against the officer. Supreme Court says, no, you should not. You should have given them him a hearing. Para 31, 32, my lord, 312.
These are the places. We are at the Helsinki Cathedral.
Correct.
This is the Senate Square.
Tempeliaco's Rock Church.
I'm sorry, my lord. I'll ask Mr. Kohli to. I think inadvertently he has switched on the mic. I'll ask request.
Lordship, I'm very sorry.
It's fine. Para 31, my lord, at 312. Having gone through the salient judgments on the issue in hand, one thing is that emerges very clearly.
Just a moment.
Where is Mahavir? Mahavir Singh भी करो some. Quick. 46, same one. There are 31, 32, my lord.
Yes.
Having gone through the salient judgments on the issue in hand, one thing which emerges very clearly is that if it is a case of deciding the suitability of a probationer, and for that limited purpose any inquiry is conducted, the same cannot be faulted as such. However, if during the course of such inquiry, any allegations are made against the person concerned, which results into a stigma, he ought to be afforded the minimum protection which is contemplated under 311(2), even though he may be a probationer. Please mark this, madam. So, my lords, if you do it for the purposes of suitability, that this officer is unsuitable for the job, her service record during probation is not good, then court says it is fine. But if you go into, my lords, allegations are made against the petitioner concerns which results in a stigma, he ought to be afforded minimum protection which is contemplated on 311(2), even though he may be a probationer. The protection is very limited. Please mark this, my lord. Which to inform the person concerned about the charges against him and to give him a reasonable opportunity of being heard. Having noted the facts as they have emerged on the record, can the preliminary inquiry conducted against the respondent in the present case be said to be an innocent one only to assess her suitability? Definitely not suitability, my lords. They are digging out, my lords, the Dibrugarh police station case records, obtaining opinion of the Advocate General, obtaining opinion of the Personnel Department, obtaining opinion of the Chief Minister. And then, my lords, is it not apparent that certain aspersions were cast on the character of the respondent during the course of conduct of this inquiry on her suitability? If that was so, it is not expected from a high judicial institution like the High Court to afford her the minimum opportunity to defend herself. In some sense, this court has observed subordinate courts and so on. But to the same effect, just have page 256 of Mahavir Singh. (264) of this compilation, Union of India versus Mahavir Singh starts at page 244 at 264. I'll not read that much, just mark that paragraph.
Page number
256, running page. Judgment starts at 244. Paragraph 46, 45, 46.
Just one. Paragraph number
46 at 256.
Yes.
As has already been held in some cases cited before us, that if a finding against the probationer is arrived at behind the back on the basis of the inquiry conducted into the allegations made against him, heard, and if the same form the foundation of the order of discharge, the same would be bad and liable to be set aside. On the other hand, if no inquiry was held, or contemplated, and the allegations were merely a motive for the passing of an order of discharge of a probationer without giving him a hearing, the same would be valid. However, the later view is not attracted to the facts of this case. So in this case, also, my lord, when an inquiry is held against the probationer, my lord, against the officer, and which forms the basis of the order, my lord, and that is disclosed at 453, your lordship saw, my lord, that file moved, my lords, all over. Dibrugarh police station records are called for from the police. It goes to the personnel department. Their view is taken. It goes before the Honorable Chief Minister. It goes before the Advocate General. And finally, a decision is taken, my lords, to discharge us, which was behind the back. Now, my lords, on the other aspect, my lords, of 3 approvers, your lordships, no, my lords, there are 57 plus 3. Total of 60, which according to the state are tainted officers. 57 have been discharged. The 3 approvers have not been discharged. Right, my lords? My learned friend cited 2 judgments, my lords, on approvership. How an approver approval is granted, my lords. How, my lords, pardon is granted under 306 CRPC. My lords, we are not questioning the grant of pardon. My argument was, my lords, that an approver can be understood, my lords, that for the purposes of the criminal case, my lords, he is granted pardon. But if he is tainted, my lords, like the 57 others, this amounts to hostile discrimination, that you allowed the 3 tainted officers to continue in their post. I mean, the other aspect, my lord, your lordship recalls that the single judge, my lord, made an observation in paragraph 46 at page 453, 454, my lord, that no judgment has been cited to show that a pre-recruitment illegality will also form under misconduct. Lordships recall that. Our case was, my lords, there were 3 judgments cited before the single judge. One was that Ratnesh Chaudhary, my lord, which Mr. NNB Chaudhary.
Mr. NNB Chaudhary referred
Yes.
to 2.
Ratnesh Mahipal Singh Tomar. And I also stated, my lord, Binapani Dey was a case of a pre-recruitment anomaly because she had entered the service by misstating her age. Right, my lord? My learned friend, my lord, distinguished this judgment, but we are not saying, we're not on the facts of that case. Our case is, my lord, that those were cases of pre-recruitment anomalies, which were very much cited before the learned single judge. So this finding of the learned single judge at para 46 is erroneous. Ratnesh Chaudhary, Mahipal Singh Tomar, and Binapani Dey are judgments of pre-recruitment anomalies. And the learned single judge, with respect, my lords, erred in holding that no judgment was cited. My learned friend, my lord, in fact, distinguished Ratnesh Chaudhary on facts. We are not on the fact. We are saying it's a pre-recruitment anomaly, which tantamount to a misconduct. Now, my lords.
Just give those 3 cases.
Ratnesh Chaudhary. Ratnesh Chaudhary, your lordship will find, my lord, in my compilation here. But your lordship had marked extensively in NNB Chaudhary's compilation, my lord. Ratnesh Chaudhary is 2015.
No, Ratnesh Chaudhary, I remember.
Yes. The other is Mahipal Singh Tomar, my lords. Appointment of principals, my lords. 2013-16 SCC 771. 2013-16 SCC, page 771. This is, my lords, page 3136 to 342 of my compilation. 316 to 342 of my compilation. Volume 2. And Binapani Dey, my lords, that judgment, my lords, in administrative, that even for administrative, in administrative law also, in administrative proceedings also, my lords, natural justice will have to be observed. State of Odisha versus Binapani Dey. This is AIR 1967.
Spelling DEI.
DEI, yes. DEI. AIR 1967. Supreme Court 1269. This is at pages 87 to 90 of volume 1 of my compilation. Now let's much has been said, my lords. Before that, my lords, my case also was, my lords, if your lordships recall, that the learned single judge got swayed, my lords, with alleged confessional statement of the appellant. Lordships recall that, my lord, that 47 lakh bribe was paid to secure her employment. That averment your lordship saw, my lords, in the additional affidavit with a highlight, my lords, with a head note that she secured her employment, my lords, by payment of bribe. That the lordships will see, my lords.
I remember Mr. Mishra made the submission.
Yes, please. So that's 45 lakh bribe was
45,
paid.
then it became to 25 to 40 lakh.
40, yes, lordships recall. Now, my lords, paragraph 44, paragraph 46, and paragraph 47 of the impugned judgment records at 3 places that these appellants entered the services by paying bribe. Paragraph 44, 46, and 47. And, my lords, the single judge says no decision has been placed to show that the police record cannot be looked into. My respectful submission which I made in my opening was that this is barred under the law. Even Mr. Mishra, sir, my lords, pointed out. Section 25, Section 26 of the Indian Evidence Act. And these are confessions allegedly extracted, my lords, during police custody. And these were handed over allegedly, my lords, in a seal cover. We have not seen it. Till date, my lords, your lordships remembers, till date, my lords, we have not seen, my lords, those confessional statements. It is not part of the records before the trial court. And, my lords, it is not even mentioned in the charge sheet number 6, where, my lords, the allegations are made against the appellant. No, reliance on this statement, my lords, which otherwise is barred.
This is something which is very, very tricky. Now, with the limited knowledge we have of the procedural part,
Yes.
see, my esteemed sister would be more equipped with this, but still, I'm trying to make a
Sir,
point.
please tell.
You see, when A is an accused,
Yes.
his statement recorded under section 161
Yes.
will be his statement.
Can be inculpatory or exculpatory.
No, whatever be.
Yes.
But in this, so far as he is concerned, he does not get a copy of that. The reason is that statement against the accused person will be through the mouth of the IO, and therefore it will be the IO statement. It will be in the 161 statement of the IO, where he will make a reference that so and so came before me and gave me a confessional statement.
That your lordship is right. That, my lords, if it is a statement under 161, today, my lords, 161 is a statement of the witness. I am summoned as a witness, my statement is recorded under 161. Right, my lord? Tomorrow, if I am turned into an accused, that 161 statement, my lords, will be of no relevance. Why? Because, my lords, it'll implicate me or whoever it is. My lords, in this case, it is not the case of 161 statement. Their case is I confessed while in police custody.
Confession in police custody is not a confession before the magistrate.
No, it is barred.
So under 164, so other arguments can follow, but
Yes.
the
No,
the argument which is sought to be made that we did not have a copy of that.
Yes.
I think copy will never be available.
One thing is this. 161 is of the witnesses. In Nandini Satpathy, my lord, Supreme Court has said that a 161 witness can tomorrow turn into an accused. At the stage when she is a witness, she was summoned, later on she was turned into an accused. Then the court said that this is a statement which cannot be relied upon because it will implicate her. She is an accused today. She has the protection. Secondly, my lords, if in her statement she has implicated some co-accused, it's a statement of a co-accused. It is inadmissible. Law grants this protection. Here it is not their case, 161 statements. They are saying, my lords, that I confessed to the crime of having paid a bribe during my custody. It's hit by 24, 25, 26 of the Indian Evidence Act. Confession is barred, my lords. Now, assuming there is a confession, well, we should see it at least. Your lordships have not seen it, madam. Now the records have been given to the accused. If I have a confession, my lord, which the police wants to rely upon, or a disclosure made by an accused, then those are part of the police papers. It will be handed over. For whatever it is worth, my lord, that confession, whether it is be proved in evidence or not, is different. But the document we have to see, my lords. We have not seen the light of the day. And this is what has happened, my lords, in that seal cover. Whereas those documents gone, we do not know. And that has resulted, my lords, in travesty of justice, my lords, before the single judge. I most respectfully submit this, my lords. And your lordship says, now, man, leadership is right, man. What the police do during investigation is, man, supposing there is a disclosure made, immediately 164 is recorded before the ministry. That is the norm. So that, my lords, the witness cannot resign.
We were that audible.
No, my lords, over the years, my lords, we also have that. We have gained that, my lords, to read the lips also. So 164 is recorded. I'm bow down to your leadership, man. Where is that one? There's no 164 here. Not even recorded, man. They could have taken them to the magistrate and then call the magistrate during the trial. Magistrate will say, I recorded it. It's good, man. That time.
That's why in one of the one of the movies of which one dialogue I remember is that in Mr. India it says Mogambo Khushwa.
No, that's
quite an iconic dialogue, lordship. I mean, for
Yes.
generations, people remember it.
Pardon me, I did not get it.
I said that's quite an iconic dialogue. That particular dialogue, for generations, several people who have seen it have remembered it.
Not even that. I go a step ahead. It is referred to in on 19 occasions in that movie.
Oh, I didn't know that, lordship.
We didn't count.
That I didn't know.
That was a blockbuster in those days. No, that's
No, those were good days where we
Yes.
had time. Even to count that.
We didn't have mobiles, lordship. That's the secret.
No, Malad, on seal cover, Malad, I have made my submissions, Malad. Mr. Mishra also has made extensive submissions. The law is, my lord, seal cover should not be allowed. Seal cover, my lord, defeats the rights of the writ petitioner. It gives an undue advantage to the state. And seal cover records, my lord, the Honorable Supreme Court has said, only furthers opacity. And what I formulated my submission in my opening was that the principles of natural justice here has been flouted at two stages, my lords. One, when the administrative authority discharged me without a hearing. And second, in the proceedings before the single judge, where, my lord, seal cover records are handed over and the Honorable Judge has made findings on the basis of seal cover. That's why I beseech your lordship, my lords, to return any seal covers which is there, my lords. Because this will be problematic, my lords. Tomorrow, Supreme Court, somebody, other party may say the court relied upon seal cover. And my learned friend's only argument was on seal cover was it has been done in Rafael case and Bhima Koregaon case. And the law has changed subsequently, man. Madhyamam Malas is Justice Chandrachud's judgment in 2023. Commodore Amit Sharma Malas is a later judgment. All these judgments have said now that seal cover should not be relied upon. Seal cover should not be looked into because it gives an unfair advantage to the state. And look at the state here, my lords, who is, my lord, switching their stands according to their convenience from a no hearing contemplated under Article 6, Rule 19, to, my lords, saying that it will be a useless formality during oral arguments. And now with seal cover, my lords, we obviously, my lords, the litigant does not get a fair deal. something which your lordships will look into without my lord disclosure to one side, my lords, is obviously, my lords, contrary to justice. And seal cover, in my respectful submission, my lords, after the judgment in Madhyamar and Commodore Amit Kumar Sharma, is impermissible. And the courts have said, my lords, as a matter of law, that seal cover documents should not be looked into by a court. The only exceptions are national security issues, my lords. If it is national security, then foundation has to be laid in the pleadings. And that too, my lords, in Madhyamar, the Supreme Court says, we will appoint an amicus, a lawyer of standing, who will go through the records in the seal cover. It's never, my lords, absolute that you'll hand over a seal cover to the court and court will rely upon. Disclosure is the rule. And non-disclosure of the seal cover record, my lords, has resulted in travesty of justice, my lord, before the single judge. No, lords.
There's two decisions you cited that.
Yes, the judgments, my lords, which I had cited.
That Mr. Mishra has also cited.
Yes, Mr. Mishra cited, my lord, one of them, Madhyamar, that uplinking Kerala judgment, my lords.
Yes.
Mr. Mishra cited of that also. I had cited Madhyamam is 2023 13 SCC.
Just a moment.
2023 13 SCC 401.
Just a moment. Please give it again.
2023 13 SCC 401. Madhyamam, MADH.
Yes.
Madhyamam Broadcasting Limited. Here, the uplinking license of the channel was declined. Court relied upon seal cover. Both the single judge in the division bench. Supreme Court came down heavily, my lord, and laid down, my lord, guidelines here. I placed that. That's part of my compilation, my lord, volume 1, pages 325 to 433. Your lordships had marked it during my opening arguments.
325 to
433 of my compilation, volume 1.
Yes, yes.
And the Commodore Amit Kumar Sharma, my lords, is 2022 SCC online.
Just a moment. Amit Kumar Sharma.
Yes. Commodore CDR dot Amit Kumar Sharma versus Union of India 2022 SCC online SC 1570. The paragraphs are 21, 26, 21 to 26 and 28 and 29. This is part of my compilation, my lords, pages 314 to 324.
Same volume 1.
Volume 1.
This, I think we had marked it.
Yes, yes. The lordships had marked it, extensively placed this one. It's part of that volume 1. Now, my lords. Now, lastly, my lords, much has been argued before this court on public good, public trust, and public interest. And the argument is, my lords, that they are holders of public office in public interest. There is an implicit public trust in this office. And relying on paragraph 44, my lords, of Tulsiram Patel's case, the state has argued that they are unworthy of holding a public office. And why am I unworthy, my lords? Because we are tainted. And why are we tainted, my lords? Because we are implicated in Dibrugarh police station case. Now, my lords, please have my volume 4, my lords. One judgment I will cite, my lords. Manoj Narula. This was cited before the single judge by Mr. K. N. Chaudhary. Manoj Narula. My lords, Manoj Narula was a case where a writ was filed before the Supreme Court to debar members of parliament, MLAs, and from contesting elections if they have criminal cases against them. To debar them from being appointed as ministers because they have criminal cases against them. Whereas these ministers, members of parliament, MLAs also occupy a public office in public trust, in public interest. And please see what the Supreme Court says, madam.
But that is, you see, that would depend. I don't know about the case, but that would go from the Representation of People's Act.
Yes,
and
yes.
Then
No, no.
PUCL decided
Yes, yes.
that it what would be the parameters and 6 months.
Yes. Those are, if you are convicted, the issue.
No, not even convicted. If there's a charge against you, or
No, no,
charge has been
no.
explained.
No. If charge has been there, you have to disclose it in your affidavit of
Affidavit.
disclosure under Form 16A, my lords, and before the
26.
election
26.
26. I'm grateful, my lord. That Association of Democratic Reforms case, my lords. So you have to disclose. Here the issue was bar them from contesting elections, bar them from holding public offices because they are detained, because they have criminal cases against them. Right, my lords? Now, in that context, my lords, please have what the Supreme Court says, my lords, on the registration of a criminal case. And I will close my argument on this, my lords. No, I'll also refer to, my lords, the DTC judgment, my lords. Just have, my lords, para 121. It's a thick judgment, my lords. I have given the relevant passage at page 2. Otherwise, my lords, the judgment I have handed over. Issues of criminal antecedent lordships has that, my lords. Page 2 of my compilation, volume 4.
Just a moment.
And this was cited, my lord, before the learned single judge by Mr. K. N. Chaudhary. It's recorded, my lords, in the impugned judgment. Page 2, my lords.
Page
2 of my compilation.
Okay.
Otherwise, your lordships will have page 64 of this judgment.
Oh, in this you have given.
It's just the relevant part.
Okay,
It's a thick judgment, my lords.
Okay.
I didn't want to scare your lordships, my lords, with a thicker compilation, my lord.
Good.
Issue of criminal antecedent lordships have page 2.
Page 2, yes.
Paragraph 121. Para 121 minutes. The expression criminal antecedents or criminal background is extremely vague and incapable of any precise definition. Does it refer to a person? Please mark this, very relevant, my lords, for our case. Does it refer to a person accused but not charged or convicted of an offense? Or a person charged but not convicted of an offense? Or only a person convicted of an offense? No clear answer was made available to this question, particularly in the context of, please mark, my lords, presumption of innocence that is central to our criminal jurisprudence. Therefore, to say that a person with criminal antecedents or a criminal background ought not to be elected by to the legislature or appointed a minister in the central government is really to convey an imprecise view. But these are public offices, man. It's in public trust, in public interest, they are holding it, man. They are elected, my lords. Now, please see paragraph 122. The law does not hold a person guilty or deem or brand a person as a criminal only because an allegation is made against that person of having committed a criminal offense, be it in the form of an off-the-cuff allegation or an allegation in the form of a first information report or a complaint or an accusation in a final report under section 173 of the CRPC, or even on charges being framed by a competent court. The reason for this is fundamental to criminal jurisprudence, the rule of law, and is quite simple, although it is often forgotten or overlooked. Yeah, but obviously the state has forgotten it. State has overlooked it. A person is innocent until proven guilty. This would apply to a person accused of one or multiple offenses. At law, he is or she not a criminal. That person may stand condemned in the public eye, but even that does not entitle anyone to brand him as her as a criminal. Here, my lord, we have been branded as a criminal. We are tainted officers. Now, consequently, merely because a first information report is lodged against a person or a criminal complaint is filed against him or her, or even if charges are framed against that person, there is no bar to that person being elected as a member of parliament or being appointed as a minister in the central government. I add here, my lords, these are public officers held in public trust, in public interest. Now, my lords, What is sauce for the goose is sauce for the gander. If the registration of Dibrugarh police station case itself is enough, my lords, to condemn these appellants, the Supreme Court has said no. These are only accusations. You cannot condemn them. These are public officers held in public trust, in public interest. My learned friend's argument, my lord, was reverberating throughout. These are officers of public good, for public interest. And this was, my lord, relying on Tulsiram Patel, paragraph 44. My respectful submission is, my lords, what is sauce for the goose is sauce for the gander. State cannot do this, my lords. With respect. And this is the only taint against this officer, the registration of the Dibrugarh police station case. Now, my lords, I pause here for a moment. Just have, my lords, this compilation itself. Olga Tellis, my lords, para 44, I am not reading, my lords, recall, my lords, where the Supreme Court in Tulsiram Patel said that the matter of livelihood is only concerning his family. Lords, recall that, my lords. It's his private interest. Now, please have Olga Tellis. Olga Tellis was delivered, my lords, 1 day prior to Tulsiram Patel, 10th July 1985. Tulsiram Patel is 11 July 1985. And just see, my lords, paragraph 32 at page 4. What the court says, my lords, on livelihood. Last line, my lord. Para 32, I'll read. As we have stated while summing up the petitioner's case, the main plank of the argument is that the right to life, which is guaranteed under Article 21, includes the right to livelihood. And since they have been deprived of their livelihood, if they are evicted from the slum and pavement dwellings, their eviction is tantamount to deprivation of their life and is hence unconstitutional. For purposes of argument, we will assume the factual correctness of the premises that if the petitioners are evicted from the dwelling, they will be deprived of their livelihood. Upon that assumption, the question we have to consider is whether the right to life includes the right to livelihood. We see only one answer to that question, namely that it does. The sweep of the right to life conferred by Article 21 is wide and far-reaching. It does not mean merely that a life cannot be extinguished or taken away, as for example by the imposition and execution of a death sentence, except according to procedure established by law. This is but one aspect of the right to life. An equally important facet, please mark that, Malak, of that right is the right to livelihood. Because no person can live without the means of living, that is the means of livelihood. If the right to livelihood is not treated as part of constitutional right to life, the easiest way of depriving a person of his right to life would be to deprive him of his means of livelihood to the point of abrogation. But such deprivation would not only denude the life of its effective content and meaningfulness, but it would make life impossible to live. In this respect, we'll just have Delhi Transport Corporation at page 7. This is a Constitution Bench judgment, where the validity of Regulation 9(4) of the Delhi Transport Corporation regulations was under challenge, which enabled, the Delhi Transport Corporation to hire and fire, officers. Now, in this case, see what the Supreme Court says at paragraph 230, at page 8 of my compilation.
Applying the same principle, one of the richest democracies in the world has now done it. It has even closed down investigating wing.
Yes. Yeah, sure. These are matters of livelihood, You can't do it like this. And then the state says, no right is infracted. No fundamental right is infracted.
It already also stated that the judge who interferes would also be proceeded against.
No, that cannot be done. That will not be done, That will never be done in our democracy.
No, I'm not speaking of here. I'm speaking of
I
other
know.
countries.
That I understand. Yes.
Here, I don't know.
No, here never, very robust now. We're very robust. Our democracy here. There, obviously, there is a need to minimize para 230,
Yes,
page 8.
Yes.
There is a need to minimize the scope of the arbitrary use of power in all walks of life. It is inadvisable to depend on the good sense of the individuals, however high placed they may be. It is all the more improper and undesirable to expose the precious rights like the rights of life, liberty, and property to the vagaries of the individual whims and fancies. It is tried to say that individuals are not and do not become wise because they occupy high seats of power. And good sense, circumspection, and fairness does not go with the post, however high they may be. There is only a complacent presumption that those who occupy high posts have a high sense of responsibility. The presumption is neither legal nor rational. History does not support it, and reality does not warrant it. In particular, in a society pledged to uphold the rule of law, it would be both unwise and impolite to leave any aspect of its life to be governed by the discretion when it can conveniently and easily be covered by the rule of law. Well, para 231, the employment under the public undertakings is a public employment and a public property. It is not only the undertakings, but also the society which has a stake in the proper and efficient working. Both discipline and devotion are necessary for efficiency. To ensure both the service conditions of those who work for them must be encouraging, certain, and secured, and not vague and whimsical. With capricious service conditions, both discipline and devotion endangered and efficiency is impaired. Then 232 minutes. This is after Olga Tellis minutes. The right to life includes right to livelihood. The right to livelihood, therefore, cannot hang on the fancies of individuals in authority. The employment is not a bounty for them, nor can its survival be at their mercy. Income is the foundation of many fundamental rights, and work alone is the sole source of income. The right to work becomes as much fundamental. Fundamental rights can ill afford to be consigned to the limbo of undefined premises and uncertain application. That will be a mockery of them. And let's 236 denounces this. Then 295 minutes. 295 I'm citing for the reason because the state says no fundamental right is violated, no legal right. In EP Royapa was the state of Tamil Nadu, Bhagwati Justice as it then was held that Article 14 is the genus while Article 16 is a specie. Article 16 gives effect to the doctrine of equality in all matters relating to public employment. The basic principle which therefore informs both Article 14 and 16 is equality and inhibitions against recruitment. Please mark this part, which I quoted in my opening today. Equality is a dynamic concept with many aspects and dimensions. It cannot be cribbed, cabined, and confined within traditional and doctrinal limits. From a positivistic point of view, equality is antithetical to arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to the whims and fancies of an absolute monarch. Where an act is arbitrary, it is implicit that that is unequal, both according to political logic and constitutional law, and is therefore violative of Article 14. And if affects any matter relating to public employment, please mark this, it also violative of Article 14. 16. Articles 14 and 16 strike at arbitrariness in state action and ensure fairness and equality of treatment. In Nagaland, it was further held, prison of reasonableness. Then para 294 refers to Olga Tellis. And 299, if your lordships come at para 14. (299) refers to Tulsiram Patel. Lordships has that minutes. The Maneka Gandhi case is also an authority for the proposition so and so. Then it refers to Tulsiram Patel. Your lordships will see. In Union of India was a Tulsiram Patel. This court held principles of natural thus can be recognized. Then Motiram Deka 300. And please come to 392. Hmm. 302. Para 15. Your leadership has that, I'm sorry, I'm running a bit fast, reading it. Article 14 is the general principle, while 311(2) is a special provision applicable with all civil services under the state. Article 311(2) embodies the principles of natural justice, but proviso to Clause 2 of Article 311 excludes the operation of principles of natural engrafted in 311 as an exception in the given circumstances enumerated in the three clauses. Article 14 read with 16(1) and 311, please mark this, are to be harmoniously interpreted, and that the proviso to Article 311(2) excludes the application of principles of natural justice as an exception, and the applicability of 311(2) must therefore be circumscribed to the civil services and be constituted accordingly in respect of all other employees in the so and so. and Tulsiram Patel is explained, and the regulation was struck down. So the right has evolved, with the march of the law. The law has marched forward, So that observation in paragraph 44 of Tulsiram Patel that it impacts the livelihood of an employee impacts only his family. As subsequently, has been denuded in view of the Constitution Bench judgment in Olga Tellis, followed, in Delhi Transport Corporation case, which has said, that it is part of right to life. It is not mere animal existence. And my last judgment, is a division bench judgment of the Punjab and Haryana High Court.
Where is that Tulsiram Patel?
Tulsiram Patel, I had handed over as a loose thing in my.
Okay.
Lordship has it, Paragraph 44, which my learned friend Lordship wants to have a look,
Yes, yes.
Yes, yes. Paragraph 44, if your Lordship says, We'll just come to it in once. Paragraph 44, at page 442.
Yes,
Ministers frame policies and legislatures enact laws and lay down the mode in which such policies are to be carried out and the object of the legislation achieved. In many cases, a welfare state such as ours, such policies and statutes are intended to bring about socio-economic reform and uplift of the poor and disadvantaged classes. But your Lordship will mark that, Ministers frame policies and legislatures, enact laws, and lays down the mode. Down further. The public is therefore vitally interested in the efficiency and integrity of such services. Government servants are all paid from the public exchequer, to which everyone contributes either by way of direct or indirect taxes. Those who are paid by public and are charged with public administration for public good must therefore in their turn bring to the discharge of the disease a sense of responsibility.
Because I had checked up.
Yes, ma'am.
This what do you call in the search, this principles of Tulsiram Patel has not been overruled anywhere.
No, it has not been. What I'm saying, with the march of the law has developed, law has evolved. Tulsiram Patel, I'd said one day prior came the judgment in Olga Tellis, which held right to life is an important facet, that livelihood is an important facet of right to life. And that march, was carried forward in Delhi Transport Corporation case. Well, it says even in public employment, it cannot be whims and fancies that the person is. I'm not saying, it's been overruled. All I'm saying is, with the march of the law, this principle, stands denuded. And not only this,
In short, it died a natural death.
No. And not only this, this principle, if your Lordship, that's why I pointed Manoj Narula to say, these are also public offices, ministers are holding public offices. And I said, the proverb, what is sauce for the goose is sauce for the gander. If the Supreme Court has said, that registration of a criminal case, framing of charge means nothing, there is a presumption of innocence, then how can the state today say that mere registration of Dibrugarh police station case against the petitioner is enough, taint to remove them? Now, the last decision which I am citing is the division bench judgment of the Punjab and Haryana High Court, authored by Justice G.S. Singhvi, as his Lordship then was. This is page 20 of the compilation. On public offices, This is page 20 of my compilation 4, at page 35. What's it say? Page 35.
Yeah, just one.
This is Division Bench of the Chandigarh, Punjab and Haryana High Court. Para 25.
Yes.
Lordship has been page 35.
Yes.
Having given this wider meaning to the term life, the court cannot swerve from its responsibility to protect the right to livelihood of the individuals. The court cannot shut its eyes from the reality that in our country, please mark this minute, public employment is an important source of livelihood to individuals. And service jurisprudence, which has developed during the last 4 decades, has perhaps no parallel in the world. If the courts have safeguarded the right to speech and expression, the right of business, the right to property, the right to form association, it cannot remain oblivious and ignore the rights of millions who are deprived of the source of livelihood by arbitrary, capricious, and whimsical actions of the state and its agencies. The court cannot throw out a petition, but then it says we cannot throw out. So declaring it not. So-called sacrosanct rights, which are treated as basic rights, even by the Universal Declaration of Human Rights, will remain mere paper if the man is not in a position to sustain himself and the family. Please mark that part, my lord. It is therefore of vital importance, the court as well as citizens, that right to livelihood is adequately protected.
This proposition we have to accept, because if a person has to has an alternative remedy to go to Central Administrative Tribunal
No,
or Assam Administrative Tribunal, it can't be said that the court can still entertain. Writ petition is bad otherwise.
So that's different, madam. But the court has said, madam, in such cases when right to a livelihood is involved, madam, court can refuse, madam. Otherwise, normally, yes, your lordship will send them back. But in cases that facts after facts, madam, cases are there. But what I am emphasizing is, madam, what the court says, madam, on public employment. That this is today, madam, the right to life is an intrinsic part of right to life, right to livelihood. So, madam, that observation in paragraph 44, madam, will have to be read and construed in the light of the march of the law, madam. The law has developed. And to say, my lord, it only involves his family, my lord, may not today, my lord, hold good. Now, my lord, before I end, my lord, one judgment which my learned friend cited was Naresh Kumar versus State NCT of Delhi. Your lordships, I'll not open. Lordships, remember, my lord, the driver's case, my lord, DTC driver's case, where, my lords, a division bench of the court, Justice Tushar Gadela, my lord, authored it, sitting with Justice Sachdeva, held that there was a reference to the FIR, my lord, in the discharge order. The court said that this reference to the FIR was unnecessary, because otherwise it was his service credentials which was taken into consideration. So the Delhi High Court says that can be expunged. And taking a clue from that, my lord, my learned friend argued, my lords, the reference to the FIR may be expunged. My lords, in my respectful submission, that judgment is contrary to the Supreme Court judgments, which says that you'll read the order. If the order is stigmatic, your lordships will quash the order. Your lordships will not say expunge this. With that thought, my lords, just please have page 249 of the discharge order of the appellant here. Just see the discharge order, my lord. I close, my lord, with a thought, my lord. Just have the discharge order at page 249. Neither the single judge, my lords, and I am also making a grievance against Mr. Kohli, my lords. He completely ignored my submission, my lords, on the discharge order. Page 249, my lords.
Not at all, lordship. Not at all. Not at all.
Maybe I couldn't make that impact, my lord. He completely ignored my submission. 249.
Now my learned friend is fishing for compliments, Lordship.
No, I'm not. 249 minutes. Your Lordship has that minute. Till the first three paragraphs, my Your Lordship will see. Whereas Suranjita Hazarika had appeared in the combined CC, whereas on recommendations of APC was appointed temporarily, whereas after completion and release from the joint induction temple had joined in the commissioner and subsequently was posted in the regular place of posting. After this, my lords, starts the reference to the Dibrugarh PS case. The Lordship has those paragraphs, my lord. Now, from whereas a report has been received from the Commissioner of Transport Assam that Suranjita Hazarika was arrested on 18/7 in connection with Dibrugarh PS case for the prevention of offences under prevention of corruption, etc. Your Lordship will skip everything, my lords. It refers to the investigation, course of investigation, FSL report. Then, my lords, please come, my lords, to the last paragraph. Because, my lords, the penultimate paragraph, your Lordship says, in view of the above. What is the above, my lords? Dibrugarh PS case and the investigation in Dibrugarh PS case. Right, my lords? In view of the above, it is found from the copies of the records that the case of Suranjita is similar to APS probationer since he appeared in CC 14. Now, let's please see. Now, the governor of Assam in exercise of powers and rule. Now, if from the fourth paragraph till, my lords, in view of the above, that paragraph is expunged according to the judgment of the Delhi High Court in Naresh Kumar, what remains of this order? It does not, my lord, please mark one thing, my lords, here. This order does not record. Where is the assessment of the suitability here, my lords? Where is the assessment of performance being unsatisfactory here? If suitability and performance was the factor, my lords, then I had no case. Then your lordships would have said it is not stigmatic. Your performance was not satisfactory. Where is the assessment of suitability here? Where is the assessment of performance here? The only reference and reliance is on the FIR registered in Dibrugarh PS case and the investigation pertaining thereto. So, my lords, on the bare reading of this order itself, my lords, this order, my lords, is stigmatic. It is punitive, my lords. And I was entitled, my lords, to the protection under Article 311. No, before I end, my lords, I live with a thought, my lords, that these are officers, my lords, who were selected, my lords, in a competitive examination. 2013, 2014 officers. They joined. And as I stated earlier, my lords, I reiterate once again, my lords, for your lordships, note that there is no adverse reports against any of these officers after they joined the service. Rather, my lords, there are recollects, my lords, my client has been said that she has satisfactorily completed her training. These are otherwise, my lords, trained manpower who have rendered service in the state. Today, my lords, because of these discharge orders, they are unemployed. They have been socially stigmatized. They are all sitting at home. They are overaged today. They are, my lords, they can't take up any other employment. And the reason is this, my lords. We are caught, my lords, in a political crossfire. Because these appointments were made, my lords, in 2012, 13, 14. The regime changed in 2016. We can't, my lords, fight the might of. So these officers today, my lords, are sitting idle at home. They are otherwise, my lords, resources who are trained resources. So my humble prayer, my lords, to your lordships, and I beseech your lordships to consider that your lordships will balance the justice, my lords, and see, my lords, how, my lords, these officers otherwise, my lords, have no antecedents otherwise, except, my lords, what has been alleged, my lords, in the Dibrugarh PS case. And I, my lords, close, my lords, with a humble prayer, my lords, that this orders should be set aside, the impugned order. And, my lords, the impugned discharge orders be quashed, my lords, and all consequential actions be set aside. With that, my lords, your lordships have page 427. What I'll pray, my lords, to your lordships. If your lordships are to decide, my lords, in favor of the appellant, then your lordships will have to balance, my lords, the equities. This is the latest judgment of Justice Nagratna of the Honorable Supreme Court, my lords. This was placed by NNB Chaudhary, my lords. It's part of my compilation, Sarita Chaudhary. At 427, your lordships have, my lords. Volume 2.
Volume 2.
Yeah. It starts at 370 minutes. Justice Nagratna and Justice Kokeswar Singh. At 427 minutes. And this, my lords, I would humbly beseech, my lords, to consider, my lords, if your lordships are to reinstate, are to allow my appeals and quash the discharge orders, the lordships will have to balance the equities. And one form, my lords, I'm just placing it, my lords, at page 427. Lordships has this, my lords. Para 18. In the result, we set aside the termination orders which have reached the petitioners here, including resolution so and so, and all consequential adverse orders, if any. The petitioners are reinstated in the service with all consequential benefits subject to the following conditions. Number one, my lord, are directed to declare their probation as on duty. The juniors were confirmed. Petitioners herein shall not be entitled to any salary from the date of termination till their reinstatement, but the monetary benefits for the said period shall be calculated notionally for the purposes of pensionary benefits, etc. It is directed that the petitioner shall be reinstated into the service within a period of 15 days from today in accordance with the seniority they possessed as on the date of the termination. The complaints, if any, which are kept in abeyance by the orders of the Chief Justice owing to termination may be dealt with in accordance with law. This is something, my lords, your lordships can consider, my lords, in the event your lordships are to, my lords, allow the appeal and set aside, my lords. And I'm very grateful, my lords, for a patient hearing. It was a pleasure to appear before both your lordships. I'm grateful.
Lordship, I will also repeat the last sentence, which my learned friend has said. We are very grateful for that patient hearing. Just two things, Lordship. Our written submissions are almost ready. Lordship may give me the indulgence of giving it to Lordship, filing it tomorrow morning, because one or two points we will add based on today's hearing. Second, Lordship, just as a clarification, if Lordship wants me to address it, I'll put it in the written submission. On the sealed cover, the judgments are not applicable because the sealed cover was considered in 2020, 18, 19, 20, and the applicable judgments at that time permitted seeing it in a sealed cover. Currently, the sealed cover relates to the arguments, particularly in Writ Appeal 96, which was Mr. Diganta Das, learned senior counsel, had Diganta Das had argued the matter, and therefore, in that sealed cover issue, it was regarding the investigation related to the 9-page loose sheets. And this will not mitigate against the current appellants, because that 9-page was you didn't take action against others. The state said we are showing action, SIT has done, so the further charge sheets were filed. But if Lordship wants me to address it, I can add another 2-3 pages on that in our written submission. That's what I needed, a clarification, Lordship.
You may just refer to the change in law, that what you call the cases where you said that the law changed. Only that much, no further.
We'll do that, my lords.
We will certainly do that, Lordship. I'll just refer to that. It'll be just 3, 4, 5 sentences, a small paragraph.
Okay. So, for the appellants are present. The reply argument by Mr. Arnab Chaudhary and senior counsel, assisted by Ms. B. Chaudhary and counsel for the appellant in WA
14 of
2022 is concluded. Next, Mr. Naren Colin and senior counsel, assisted by from the last order. So and so, along with Mr. H.K. Hazarika and government are present. He's present online. The arguments are concluded.
Lordship,
For
Lordship closes the arguments, Lordship, with regard to item number 55, your Lordship, Writ Bill 27 of 2024, Lordship, this matter needs to be segregated from this batch, your Lordship. Or this case relates to Bhang or PS case, Lordship.
He's a convicted employee, my lord. He was convicted in the Vangagar case.
That conviction is presently under stay, your lordship. But otherwise, lordship, this matter needs to be segregated, your lordship.
Okay, Mr. Kohli,
My lords, we had
No
prayed
issue.
on the first days that it should be dismissed, my lord. Not even segregated because it's a conviction case.
Conviction is stayed, your lordship, otherwise. So this matter needs to be segregated, lordship. Rest, lordship, may
item number?
reserve it for the item number 55, your lordship. Writ Bill 27 of 2024, Hangor PS.
If it pleases Lordship, may just look at the prayers there in light of this judgment, because it was tagged on the first instance, keeping in mind that the appeal was pending here. And then Lordship may take a final call as Lordship pleases.
55.
Lordship.
Only one matter.
Lordship. Create a bit of
Okay,
problem. Lordship.
we will take a note of that.
Lordship.
This can list it later.
Lordship. So rest of Dibrugarh PS is Hangor PS. And this relates to ADO. Rest are all CCE.
Okay. The Senior Counsel for the state seeks leave to file a written note by 10:30 on 18/6/2025. Mr. Prayer is allowed. The hearing is concluded, judgment reserved.
Grateful.
So far as.
Very grateful, Lordship.
My lord, there are 6 matters. Your lordship had requested the counsel for other parties to submit 2-page note. So, my lord, I have prepared a 2-page note in respect of some other cases which I am appearing. I will hand it over to the
Courtmaster.
and should I also mention the item numbers?
Yes, don't make the item number, give the writ petition
Yes,
number.
yes, yes, ma'am.
Because when we carry it home, we don't have this cause list.
Well,
Only have the files.
Writ appeal number.
Lordship, and item numbers 35, 36 and 30. I wanted to place the Motiram Deka judgment placed by my learned senior brother. So I'll rely on
It's
that.
okay, it's covered.
Yeah. That is why I didn't bother your lordship. Just wanted to say that.
Well, along with the note, I will also hand over few judgments also. If my lord can consider.
No, unless it is cited, don't give it.
No, these are not cited, my lord.
Not cited.
Then don't give. Then don't give.
And don't give.
We have 2 days time to decide the matter. Don't add anything which is not argued. That's why we are making notes. New things, if it comes in, and it'll will not be knowing what is there to be dealt with. No.
My lord.